Good morning. Today we will hear from Kate Houghton and Marian Chapman, who appear on behalf of the Department of Justice and Community Safety. This is the fourth day of hearings in the hearing block number 5, where we are primarily hearing from the government witnesses in the priority areas of child protection and criminal justice. We'll also be hearing from Dr. Tamar Hopkins this afternoon on issues relating to police oversight and accountability. Before we start today's hearings, I would now like to invite Commissioner Hunter to give a welcome to country and acknowledgement of country.
Thanks, Chair. I'd like to acknowledge that we are on the lands of the Wurundjeri, my ancestral lands, and pay my respects to elders and ancestors and those that have come before us, to those that have given voice and fought for us to be here today. And I'd also like to acknowledge, given criminal justice today, that those that have died at the hands of the state, their families that are still dealing with the grief and loss. So Wominjeka, may Bunjil watch over us today as we conduct Aboriginal business. Thank you.
Thank you, Commissioner Hunter.
Thank you, Chair. My name is McAvoy. I appear as Co-Senior Counsel assisting the Commission for today's hearing. And I too acknowledge that we are on the lands of the Wurundjeri, and I acknowledge their ancestors and their spirits.
Could I have appearances, please? Or you're going to do your... Sorry, Georgina, I was jumping ahead.
Thank you, Chair. I appear for the State of Victoria.
Yeah, my name's Gray. I also appear for the State of Victoria with Miss Sarah Keating. We're here with a particular brief to represent the interests of the witnesses today, the Secretary and Deputy Secretary of the Department of Justice and Community Safety. Thank you.
Thank you very much.
Thank you, Commissioner Hunter, for your welcome and acknowledgement of country. I would also like to begin today by acknowledging, on behalf of the State of Victoria, the traditional owners of the land on which we meet today, the Wurundjeri peoples of the Kulin Nation. And I pay my respects to their elders, past, present and emerging. I acknowledge all First Peoples and traditional owners here today, and also those observing from elsewhere, as well as all First Peoples who have participated in this important inquiry so far. Further acknowledge that sovereignty has never been ceded. The state acknowledges the role, a great source of shame, in the ongoing overrepresentation of First Peoples in the criminal justice system. The state acknowledges the First Peoples who have died in custody or been harmed in a custodial environment, and the compounding impact of the terrible pain, sorrow and anger that this has caused for First Peoples, families and their communities. Thank you, Chair.
Thank you, Chair. I call Kate Houghton and Marian Chapman, who are both in the witness box. Ms. Houghton, could you just identify yourself, please?
Well, I'm Kate Houghton, the Secretary of the Department of Justice and Community Safety.
Thank you. And in the evidence you're about to give to this Commission today, you undertake to tell the truth?
Yes, I do.
And Ms. Chapman?
Yes, I'm Marian Chapman. I'm the Deputy Secretary of Courts, Civil and Criminal Law at the Department of Justice and Community Safety.
And in the evidence you are to give the Commission today, you undertake to tell the truth?
I do.
Thank you. Now, Commissioners, I understand that Ms. Houghton has an opening statement which you'd like to make, and I invite her to make that now.
Thank you, Mr. McAvoy. So I begin by acknowledgement of the traditional owners of the country on which we meet today, the Wurundjeri people of the Kulin Nation, and pay my respects to their elders past and present. I also acknowledge the traditional owners of country across what is now known as the State of Victoria and pay my respects to all Aboriginal people with us here today. I acknowledge the Commissioners and your leadership in this landmark process. In accordance with the preference of the Aboriginal Justice Caucus, I will use the term Aboriginal to respectfully refer to Aboriginal and Torres Strait Islander people. I would like to make several additional acknowledgements. Aboriginal people in Victoria continue to maintain their laws, care for their communities, family and children, and nurture country through spiritual, cultural, material and economic connections to land, water and resources. This is despite the ongoing impacts of colonisation and the subsequent systematic racism, dispossession of land, suppression of laws, languages and culture, and intergenerational trauma. I therefore also acknowledge the extraordinary strength and resilience of Aboriginal people in the face of historical and ongoing injustices and the survival of their living cultures, knowledge and traditions. I acknowledge that Aboriginal people's sovereignty has never been ceded. I acknowledge the ongoing leadership of Aboriginal people and Aboriginal communities across Victoria in striving to improve Aboriginal justice outcomes. In particular, I acknowledge the immense generosity, contribution and leadership of the Aboriginal Justice Caucus. I approach today in the spirit of the Commission, being the first formal truth-telling process about the impacts of colonisation and the historical and ongoing injustices experienced by Aboriginal people in Victoria. My aim is to meaningfully contribute and assist the Commission in this truth-telling process. I acknowledge that the Department of Justice and Community Safety has failed to address over-representation of Aboriginal people in the criminal justice system. I acknowledge that since the Royal Commission into the Aboriginal deaths in custody in 1991, 23 Aboriginal people have passed in Victorian prisons and 10 Aboriginal people have passed in the Victorian police custody and custody-related operations. I am acutely aware that these people died while in the custody of the state, isolated from their families, their community and their country. For their passings, I express my deep regret and sorrow for the failures of my department to prevent these passings where they could have. I am deeply sorry. I know the criminal justice system needs not only to improve to address injustices felt by Aboriginal people, but through treaty negotiate a transformed system. I also acknowledge my personal and professional commitment to this purpose and note that under my leadership, the department seeks to play a critical role to support this. My evidence today is likely to include data and statistics to demonstrate the injustices that permeate the criminal justice system, but statistics only tell part of the story. Statistics cannot begin to express the impact, tragedy, heartbreak and truth that has been powerfully told in this landmark commission. I acknowledge that each statistic is a person with their own identity, aspirations, loved ones and a story to tell. I acknowledge that research and data may be influenced by the systematic racism and bias that Yoorrook was established to address. Any data I refer to today may therefore not be fully informed by Aboriginal people's voices and experience. The evidence that has been provided to the Commission by Aboriginal people to date highlights often harrowing lived experiences of the justice system since colonisation. The criminal justice system has been and continues to be an immense suffering for many Aboriginal people. I've listened to the evidence and heard the insights generously shared by witnesses of tragic deaths of loved ones in custody, as well as their experience in sentencing, policing and prisons. My role is to listen, to learn, to be accountable through action and leadership, and to assist the Commission in this truth-telling process. I look forward to a future where the justice system can be a place of healing rather than harm for Aboriginal people. And I thank the Yoorrook Justice Commission for the opportunity to be here today, for allowing me to make these opening remarks and to respond to your questions. Thank you.
Thank you.
Ms. Houghton. I understand, Commissioners, that Ms Chapman would also like to express an acknowledgement of country.
Thank you, Mr McAvoy. I would like to also begin by acknowledging the traditional owners of the country on which we're meeting today, the Wurundjeri people of the Kulin Nation. I pay my deep respects to their elders, past and present. I acknowledge that the Wurundjeri people are also the traditional owners of the land on which I live. I acknowledge the traditional owners of country across what is now called Victoria, and I pay my respects to all Aboriginal people with us here today, including those on the live stream. I acknowledge that Aboriginal people have never ceded sovereignty. I acknowledge the Commissioners and your leadership in this formal truth-telling process. I am here to assist you in this important work. Thank you.
Thank you.
Thank you, Ms. Chapman. Now, I propose to ask a number of questions during this examination. I will address particular questions to each of you, and that doesn't mean that the other witness can't add something, but if I address a question to you, it will be my expectation that that witness answers the question as directed. There will be some questions that I put to you generally, and I'll leave that to you as a matter to who answers those questions. Thank you. Firstly, I'll start with you, Ms. Houghton. Can you just describe for the Commissioners your role at the Department of Justice and Community Safety?
So I'm the Secretary of the Department, so I have leadership responsibility and management responsibility for the department, which covers a range of portfolios. So it includes, from the criminal justice perspective, corrections, Victoria and youth justice, as well as policy and lawmaking. I also have legal responsibility for the care and safety of people in custody for Victoria.
Thank you. And just so that we can get some understanding of your professional history, can you just give a brief outline for the Commissioners?
So I've been in the public service for over 25 years. I've worked in numerous departments: the Department of Premier and Cabinet, the Department of Environment, Land, Water and Planning, the Department of Health, and in New South Wales, the Environment Protection Authority. I have an honours degree in economics and a Masters of Environment.
Thank you. And Ms. Chapman, could you describe your role for the Commissioners, please?
Certainly. So I am the Deputy Secretary of Courts, Civil and Criminal Law. I've been at the Department of Justice as a Deputy Secretary for almost 2 years in various roles covering legal and policy functions, but my function at the moment relates to the Attorney General's portfolio in civil and criminal law predominantly. Prior to that, I spent most of my 20-odd years in the public service at the Department of Treasury and Finance. I've also worked for the civil service in the United Kingdom, and I am a qualified lawyer.
Thank you. And just so that we're clear, your direct line responsibility is to Ms. Houghton?
Yes, that's right.
And Ms. Houghton, when I asked you to describe your professional history, you didn't mention the Public Service Medal that you received in June 2022. What was that for?
So that was for my work during the COVID pandemic when I was working for the Department of Health.
In relation to policy and program delivery?
Yes, that's right.
And if you could just explain to the Commissioners briefly what your work was during the COVID period for that department.
Yes, so I was seconded from the Department of Premier and Cabinet. I think it was for a 3-month period when it was to head the policy and sort of strategy area of public health. So that provided advice into the Chief Health Officer for making pandemic rules.
Did that involve coordinating a variety of inputs and agencies?
Yes, it did, yeah, across government.
And it might sound like a trite question, but do you regard yourself as a policy expert?
I do. After 25 years in the public service, in a range of policy fields, yes.
And you came to this position as Secretary of DJCS, if I can call it that, in December 22?
Yes, that's right.
Before that, you were the Deputy Secretary in the Department of Premier and Cabinet?
Yes.
And so this role that you've been in since December 22 is a promotion of sorts?
Yes, it is, yes.
And now as Secretary of the Department, you head the Justice Portfolio Board of Management. Have I got that terminology correct?
Yes, the Board of Management, yes.
How many Deputy Secretaries and Commissioners sit on that board?
So there is all of my Deputy Secretaries, so there's 9 Deputy Secretaries, and three commissioners, so the Emergency Management Commissioner, the Youth Justice Commissioner and the Corrections of Victoria Commissioner.
And Ms Chapman, you're one of the Deputy Secretaries that sit on that board.
Yes, I am.
The Board of Management is intended to provide a coordinated approach in response to the justice portfolio, is that right?
It is largely, it does do strategy across the department. It does look at corporate issues as well, such as budget, risk management, governance and strategy.
The Police Commissioner is not a member of that board.
No, he's not.
But as Secretary, you're responsible to the Attorney-General. You've nodded.
Yes, sorry.
The Minister for Police.
Yes.
The Minister for Corrections.
Yes.
Corrections, Youth Justice and Victim Support.
Yes.
And the Minister for Casinos, Gaming and Racing. So that's 4 ministers you're responsible to.
Yes.
If you and your department are responsible to the Police Minister for some of your functions, can you explain for the commissioners how it is that the Police Commissioner is not a member of the board while the other commissioners that you have responsibility to their ministers for are?
So the Police Minister, the Commissioner of Police does not report to me. He's not a direct report. He reports directly to the Minister for Police. So within the structure of the department, Victoria Police and the Commissioner of Police is separate. I do have regular meetings with the Commissioner of Police, and my Deputy Secretaries for relevant portfolios do also meet with Deputy Commissioners of Victoria Police on policy and strategy. The department does have a role in advising the Minister for Police on police policy and legislation. It does not have operational responsibilities, like in terms of advising on operational responsibilities of Victoria Police.
And that's the dividing line between operational responsibilities and other responsibilities, is it?
Yeah, that's right. So the Victoria Police Act, I think it's Section 10, makes that independence in terms of operation clear, that is the remit of Victoria Police.
Is that arrangement workable from your perspective, having been in the position for some 5 months?
It is workable in the view that the views of Victoria Police, we understand them, we ask them how various different policies and legislation would work. We represent that advice into the Minister for Police. The Commissioner of Police, through an operational lens, would also provide that advice to the Minister for Police.
And the reality of that arrangement, though, is that justice reform matters about which your agency might be progressing may be getting briefed against from the Commissioner for Police to the same Minister. Is that correct?
From an operational perspective, yes, that would be the Commissioner of Police would have his own views.
And of course, you've just discussed the meetings that you try to have at an officer level to eliminate that possibility, but it's certainly something that can happen.
Yes, that's right.
Are there any other steps that you've taken to manage that situation apart from having your officers meet?
We've actually started through an agreement. It was an exchange of letters between the Police Commissioner and myself to develop a strategic advisory committee this year. It is soon to meet, which has formally my relevant deputies. So, for example, Ms Chapman, as well as the relevant deputies, commissioners, and they meeting on a regular basis to talk about potential reforms of government in the criminal justice system.
And it's obvious, it may be obvious, but the support of, or otherwise, of the Minister for Police is very important to criminal justice related matters.
Yes, it is.
And in Victoria, would you agree that historically speaking, the Chief Commissioner for Police has not been what you might call a champion for social justice reform?
I can't comment on that. The views of the Police Commissioner are his views. What I can say is that the Victoria Police will come from an operational perspective and often the safety of their own members.
I might just take that a little bit further. You're not aware, are you, of, in your time at the department, of the police commissioner having come to you and said, well, these laws are too harsh and we need to make them easy for people to get bail?
No, that hasn't been an instance.
Do you? I might direct this question to Ms. Chapman. Your experience working in this area for a considerable period of time, do you think that every agency in the justice portfolio ought to be able to objectively assess its own impact in terms of ensuring that the work that they're doing aligns with government policy and decisions?
If I can just clarify, Mr McAvoy, do you mean agencies such as Corrections Victoria or police?
Departments and agencies.
I think in practice that does happen to a certain extent. As we develop policy, we do consult within the justice sector wherever we can to really get a deep understanding of the different elements that might need to be considered. That could be operational, it could be technical, it could be that there's a legislative reform that impacts one part of the sector that will need to be looked at. And I consider it my job to ensure that relevant ministers understand all of those impacts, and to that extent we actually encourage that deep consultation and the understanding of impacts from each of those partners.
And Ms. Houghton, you would say that the Department of Justice and Community Safety has that ability of self-reflection and an ability to assess its own performance?
Performance in terms of, can I just seek clarification?
Sorry?
Sorry, seek clarification in terms of performance of...
Performance as against the government policy and government decision-making?
Yes, yes.
Has the... we might just take that example a little bit further. The Victorian government has, as you'll both know, committed to achievement of the closing the gap target for reduction of adult incarceration by 15%.
Yes.
By 2031.
Yes.
Has a representative from VicPol ever come to either of you with suggestions as to how that the rate of over incarceration may be reduced to meet that closing the gap target?
In my time as secretary, no, that hasn't happened. No.
Ms. Chapman?
No, not come to me, but we've certainly discussed in the context of criminal justice reform how actions that we might advise government on will reduce over-representation in the system.
So in meetings where you're having discussions about the reduction of over-representation and police are involved in it, they participate in the discussions.
Yes, they do.
But they haven't, off their own bat, come to you with suggestions as to how it might be...
Not to me personally, no.
I just want to take you now to some questions about over-representation of Aboriginal people in the criminal justice system. Ms. Houghton, I might ask you to go to your department's response to the Yoorrook questions. You have that in front of you?
Yes.
If you can turn to paragraphs 11 and 12, I'd ask you if you could read that aloud for the Commissioner's benefit and to ensure that it is read into the record.
Paragraph 11, at the outset it is important to acknowledge that most Aboriginal people never have and never will be involved in the criminal justice system. Nevertheless, the exercise of power and control by European settlers resulted in ongoing dispossession of land, disruption of culture and kinship systems, removal of children, racism, social exclusion, institutionalisation and entrenchment of poverty for Aboriginal people. The systems established during colonisation often had the specific intent of excluding Aboriginal people and their laws, customs and traditions, resulting in entrenched systematic structural racism and disadvantage.
And if you could go on and read paragraph 12, please.
Paragraph 12. The survival and success of Aboriginal peoples in the face of the forces of colonisation is a testament to Aboriginal people's strength and resilience of culture and community. Despite the resilience and strength of Aboriginal people, many Aboriginal Victorians live in the social and economic inequality and circumscribed life options and life experiences. As acknowledged by the Victorian Government, systematic racism is a primary driver of the overrepresentation of Aboriginal people in the criminal justice system. Other key drivers include inequality in education opportunities, economic exclusion, lack of access to housing, child protection involvement, intergenerational trauma, mental health and substance misuse issues.
Thank you. So in the acknowledgements that you've just read, you have, on behalf of the Victorian Government, recognised that one of the primary drivers of overrepresentation is the existence of systemic racism
Yes.
within government.
Yes.
And at paragraph 14, you note that the Victorian Government has acknowledged that threads of colonial racism, although reprehensible, persist to this day, existing consciously and unconsciously in individuals, services, laws and policies. You see that?
Yes.
Can you just explain to the Commissioner what your understanding of that notion of systemic racism and the threads of colonial racism mean in a practical sense in the current context?
Thank you. In a practical context and what we see today, I will talk about the experience of people and also workforces in Corrections Victoria, as well as youth justice, and then talk to the rates of incarceration. So in terms of the Corrections Cultural Review, so this cultural review was done by government last year and was reported publicly at the start of this year. And what it found, which I see as practical demonstration of systematic racism, is that the system has a negative workplace culture with widespread racism, bullying, discrimination and sexual harassment. It has a high tolerance for racism and lack of cultural safety for Aboriginal prisoners and staff across the system. Our Youth Our Way report from the Commission of Young People also highlighted the experiences of young people and their interactions with the criminal justice system. In terms of what we see from the application of laws and policies and the policies themselves, there are a couple of examples that demonstrate the systematic racism, and one of those is the high rates of remand population for Aboriginal people compared to non-Aboriginal people, and I have some statistics if you wish to go to those. So from June 30, 2013 to 30 June 2022, unsentenced Aboriginal people in prison has significantly increased, and that's from 21% in 2013 to 49% in 2022. So in the year ending June 2022, 150 Aboriginal people were received into prison under sentence. 1,190 were on remand. So 89% of Aboriginal people who were in prison were actually on remand.
Do you find that figure shocking?
I do.
What does it tell you about how the criminal justice system is operating as regards Aboriginal people in this state?
So I particularly with bail and the various amendments of the Bail Act, they have been disproportionately impacted by those reforms.
But it's not just the reforms; it's the individuals involved in the system, isn't it?
It's the application of those laws and policies, yes.
By individuals.
Well, the individuals will be following the context and the ability of those laws provide them. Yes. Ms.
Houghton, it's not just the application of the laws; it's It's the exercise of discretion by the individuals in the system, where they choose to pursue some individuals and not others. You accept that?
I do.
And you accept that there has been complaints against the justice system, and in particular Vic Polar, about racial profiling in the past? You accept that?
I do, yes.
And so you accept that it's understood that there is a bias against Aboriginal and Torres Strait Island people that exists in government?
The bail data would suggest that and indicate that, yes.
And so that would indicate that at many levels within the system where people exercise discretion, that discretion is able to be exercised in a way which is at a disadvantage to Aboriginal and Torres Strait Island people.
I agree.
At paragraph 13, Ms Houghton, there is an admission that the overrepresentation is inextricably linked to intergenerational and compounding effects of colonisation. Those effects that are being spoken about at paragraph 13 are the ones that are referred to in paragraph 11. Is that correct?
Yes, that's correct.
If I might ask if the operator can turn the screen to page 11 of that same document, and if you can turn to page 11, Ms Houghton. If you can zoom in on the graph on that page, at the top of that page. That graph, would you agree, Ms Houghton or Ms Chapman, shows a number of things. Firstly, that the number of Aboriginal people in prison in 2013 was 388.
Yes.
And that figure had almost doubled by 2019.
Yes.
And it reduced slightly to 695 by 2022.
Yes.
The increase of approximately 230 people between 2017 and 2019 is largely a result of the amendment to the Bail Act in 2018. That's
Yes.
your understanding of those figures?
Yes, that's right.
And the increase overall reflects, or in part, a massive overall increase in the prison population in Victoria during that period.
That's correct.
So what I'm suggesting, and you've agreed to, is that in that 10-year period, there has been a very substantial increase in the prison population in Victoria,
That's correct.
which is out of all the trajectories from the previous decades.
That's right, and that's largely attributed to people on remand.
And has there been an increase in the number of correctional facilities in the same period to meet the growing demand?
There has been an increase in the number of beds in the corrections infrastructure, and there is a new prison that has been built in, it's called Western Plains, but that is yet to open.
And what size is Western Plains in terms of beds, do you know?
I can find that out. I just don't have it on top of my head.
We might find that out from another witness later this week, perhaps.
Yes.
What I will ask you at this point is, notwithstanding the recent announcements about reform of the criminal justice system and potential reform of the Bail Act, is it likely the path of mass incarceration will continue to rise in Victoria?
So I'll take that question in a couple of ways. One, the crime rate is recovering from COVID in a sense. So crime rate may increase, it may stabilise. So So from a crime rate perspective, incarceration of people that are sentenced may increase, and that's determined based on crime stats modelling. In terms of the reforms that the government, through the Bail Act, has committed to and is currently consulting with stakeholders on, the objective of that is to ensure that people that have minor and non-serious offending and repeat offending are not caught in remand. So with that aim, then incarceration should, depending on modelling and the interaction with sentenced prisoners, it should reduce.
It is the case that generally crime per capita has been reducing.
I'll need to double check that. We do publish crime stats every quarter, and I can easily provide that data to the Commission.
Perhaps Ms Chapman will know the answer.
I'm afraid I don't have those stats in front of me, but I do know there's been a reduction in a lot of the crime rates as a result of the COVID lockdowns. And from discussions with the Crime Stats Agency recently, some of the sorts of crimes that they are seeing now are changing, and some of that is a result, it's proposed, of things like people working from home. So there are different kinds of criminal activities that are going on that we need to be understood when we're looking at further reforms to drive down overrepresentation numbers.
Thank you. So it's hoped that there might be a reduction, but with an increasing population in Victoria, that may drag the figures in the other direction.
Yeah, it is a hope that people who we have minor offending, repeat offending, and would not have a custodial sentence in the first place would not be in jail.
Thank you. Now, I might ask you to turn to paragraph 20B of that document. These figures are the figures that you've cited a few moments ago.
Yes.
But they're worth repeating. In the year ending June 2022, 100 people were received into prison under a sentence compared with 1,190, 89% received unsentenced. In other words, on remand. In the same year, 735 Aboriginal people were discharged from prison having spent no time under sentence, representing 52% of all discharges of Aboriginal people. So half the people are being released without ever having been sentenced.
That's correct.
That is an astounding figure. It means that those people have served a period of time, we don't know how long, without ever having been sentenced to a term of imprisonment.
That's correct. I think further in the statement there is evidence to say that for women the average length of stay is 38 days and for men it is under 3 months.
This means that, I'll suggest to you, this means that 52% of all people, all Aboriginal people released from prison have either received bail after having it initially refused, that's the basis for their release, and I suggest to you that would be a very small minority of the matters, or they have pleaded guilty and received no further sentence on the basis of the time they've already spent in custody. You agree with that?
Yes, I do.
Back to it after morning team.
Can you think of any other time in Victoria's history that there has been such a thing?
No, I can't, Commissioner.
It is truly unprecedented, isn't it?
It is.
Taking those figures further, would you agree with me that it's highly likely, highly probable that the majority of the people who are being released without having been sentenced are have been refused bail for minor offences which attract short prison sentences.
Yes, I think that's, yes, I agree.
And are sentenced to time served when they enter a plea of guilty.
Yes, that's correct.
The very existence of those settings increases the risk substantially that people will plead guilty to offences because the time it takes to get a hearing exceeds the length of the sentence they're likely to get for their offence. I ask you, how can that be described as the delivery of justice?
I agree with you in terms of the design of the bail reforms from 2008 caused great harm and a disproportionate impact on Aboriginal people. I do not defend that. I just go back to the context of the reforms that the government made at the time, and it was seeking to balance, and clearly the balance was not right, community safety at the time after the Burke Street murders of 6 people and injuring many others. Now, those reforms came in purposefully to make bail harder and make it harder particularly for serious offences.
We'll come to some discussion about the circumstances which existed at the time those amendments were made to the Bail Act. What I want to ask you now, on the same topic that we've been discussing, is whether, and I'm sure you're aware that the Royal Commission into Aboriginal Deaths in Custody called in the strongest terms for imprisonment to be the option of last resort. You're aware of that, aren't you?
Yes, I am. Yes, I am, sorry.
That was 32 years ago.
Yes.
The system that exists at present cannot be described as a system establishing prison as the option of last resort, can it?
No.
Except that with an increased Aboriginal prisoner population also comes an increased risk of death in custody by Aboriginal people.
Yes.
And there is no way, I suggest to you, no way that the government would be unaware that any change in policy or legislation that resulted in an increase in the prison population generally would not also increase the number of Aboriginal people in prison,
Correct, agree.
and thereby increasing the number of deaths in custody.
Agree.
It's the case, isn't it, that while the population of Victoria is growing, there's likely to be an increase in prison population that we've previously discussed, noting that you are hoping for reductions in the numbers.
Yes.
But over the last 10 years, notwithstanding the most recent downturn, there's still been a massive increase in prison population over that period.
That's correct.
And as Commissioner Bell asked you, it's of a totally unprecedented nature, not something that has occurred in Victoria's history.
Correct.
The only conclusion that can be drawn, I suggest to you, Ms. Houghton, is that in that period, in the last 10-year period at least, the government was determined to increase the prison population.
I don't think that was their primary objective. The primary objective was community safety. And if I can go to that context of the government making the reforms to the Bail Act in 2018 and also 2013, in a sense, it was in response to quite significant event, and that was the Burke Street murders.
we will have a chance to go to that event, Ms Houghton. I can see you're eager, but we will get there. If you just bear with me. Thank you. At paragraphs 22 and 23 of the DJCS response, you acknowledge that the time spent on remand is dead time,
Yes.
and that inmates or prisoners don't know how long that they will be in there for. It causes significant disruption to the individuals and their families and communities, and you acknowledge that.
That's correct. It is difficult to participate in rehabilitation programs on remand.
And often there's little incentive to become involved because people don't know how long they will be there.
Yes, that's right.
And it's the case, isn't it, that whilst a person is remanded in custody, they do not get access to all of the programs that are available to sentenced prisoners.
They do get access to programs. For offence-specific programs, there needs to be an admission of guilt. So when you're on remand, you're unsentenced, so that would not be available to you.
It's also acknowledged in the response document that Aboriginal people are overrepresented in terms of recidivism or reoffending. This is at paragraphs 24 to 26, Commissioners, if you're following. Overrepresented in terms of reoffending, overrepresented in terms of supervision in the community, overrepresented in terms of breaches of supervision, and overrepresented in the youth justice system.
That's correct.
So it's not as though there's one particular part of the system that has a particularly problematic effect on the Aboriginal community. It's across the system. Is that what we take from those paragraphs?
That's correct. There is statistics to say that men are 15 times more likely to be in prison, Aboriginal women 22 more times likely to be in prison, and children and young people 8 times more likely to be in youth justice.
Ms Houghton and Ms Chapman, you're both familiar with the Uluru Statement from the Heart?
Yes.
Yes? In that document, the assertion is made in these terms: proportionately, we are the most incarcerated people on the planet. We are not innately criminal people. Does the Victorian government accept the truth of that assertion? That Aboriginal people are not innately criminal people?
Yes.
Well, the question that follows is why then can it not design a justice system that does not result in over-incarceration of Aboriginal people, over-representation of Aboriginal people at every level?
Well, it needs to change.
It's not a rhetorical question.
But it needs to change, and that is accepted from the department and from government. And not in defence, but to explain, there are multiple objectives that government makes in different times for different issues, and collectively it is unacceptable that this is the outcome for Aboriginal people.
The consequence of that proposition is that government must make different compromises and apply priorities in different places, and that's the basis of good government. Means that on the statistics that we're looking at, that routinely the decisions are made which put Aboriginal people last and expose them to the criminal justice system. Do you agree with that?
I think the statistics show that is the outcome. In terms of government decision making, there is multiple objectives, as you say, and there are ways to mitigate that impact, but it is clear that any of the mitigants has not had the weighting of the laws and policies that are in place.
So in your department, are you considering, is anybody in your department considering how it is that in every transaction Aboriginal people are left being more exposed to the justice system and other interests prevail.
It is, so we do. In every policy decision that we provide advice to the Attorney-General and to our other ministers and then into government, the impact on Aboriginal people is understood, and we consult obviously with Aboriginal people, and the Aboriginal Justice Caucus is one way to do that. Treaty, in terms of how we negotiate the change, is also part of that conversation.
With respect, Ms. Houghton, the making of an impact statement about what might happen is not the same as making decisions that will ensure that it doesn't happen. Do you agree with that?
I agree.
And there is clearly a process in train that results in Aboriginal interests being relegated to last place, because the system produces the results that it does. Do you accept that?
I accept that. Yes, I accept that.
Now, the overrepresentation of Aboriginal people in incarceration has come about even though the government in Victoria has done a number of things. And you mentioned that on a number of occasions in the departmental response.
Yes.
And so the things that the government has done is that it has supported the Aboriginal Justice Advisory Committees, the regional committees. It has supported the Aboriginal Justice Caucus and the Aboriginal Justice Forum. It's engaged in a number of Aboriginal Justice Agreements. It's now on its 4th version. It's provided resources and assisted in the design, if not designed itself, a range of programs which have been recommended by Aboriginal organisations and the Aboriginal Justice Caucus. That's correct?
That's correct.
And many of those programs are set out in your the departmental response. That's correct?
That is correct.
And it's not the case that the government has done nothing.
Correct.
And is it fair to assume that the rates of over-incarceration may have been even higher had those actions and measures not been taken? You're nodding your head, Ms. Chapman.
Yes, I agree with that.
Did you have something to add, Ms. Houghton?
There has been evaluations of the Aboriginal Justice Agreement, and I think the last evaluation 3, did represent what you just said, that if these programs weren't there, then overrepresentation could be higher.
Of course, that's no reason for the government to pat itself on the back, is it?
Correct. We need to continue to do more work.
So at paragraph 43 of the response, just turn to paragraph 43. Can you get 43 on the screen, please? The department recognises that self-determination is the key guiding principle in developing solutions. I'll just give you the opportunity to explain to the commissioners what your understanding of self-determination in the justice setting is.
So I'd firstly like to say that self-determination is not for government to determine, but in terms of my experience, self-determination creates the better outcomes because the people that are affected by the issue or the opportunity have control and design and deliver either the program or the policy. So the ultimate outcome is a better outcome.
Perhaps by way of example as to what self-determination is not. Do you accept that self-determination is not being forced to choose one option from a set of options designed by government?
Yes, that is correct, yeah. I would agree with that.
With that in mind, I ask whether the Aboriginal Justice Forum or the Aboriginal Justice Caucus has been given complete freedom to design a criminal justice model for Aboriginal people in Victoria.
No, they haven't been given the freedom to design and deliver it. It is a partnership, and I acknowledge that the Aboriginal Justice Agreement is not self-determination. It is guided by self-determination, as is the department. So the government still maintains control of resourcing policy and legislative capacity.
Well, in that light, at section 3 of the response, you go to some length to talk about the various programs and initiatives being undertaken to reduce adult overrepresentation.
Yes.
Are there any of those programs that you or Ms Chapman would like to bring to the Commissioner's attention as programs that are of particular interest to you, or are particularly exciting in terms of their potential?
I would like to talk to the Aboriginal Community Justice panels. So that work was auspiced through the Aboriginal Justice Caucus, and it's volunteers that check on Aboriginal people in police custody on their welfare. The Aboriginal Justice panels in the design of the decriminalisation of public intoxication will play a very important role in the rollout to that, and there is their importance was promoted and provided during the advice to government in terms of how to operationalise the decriminalisation of public drunkenness.
The initiatives and programs themselves represent a significant amount of work, but the tenor of the evidence today seems to be an acceptance that there is much more that must be done.
That's correct. And in terms of the Aboriginal Justice Agreement and the programs, many of these programs are designed and delivered by Aboriginal communities, and that is one of the benefits of the Aboriginal Justice Agreement. But as you say, there is much more to be done.
You have a background in economics.
I do.
You understand that as much as it is a contest of ideas, it is a competition for resources internally within government as to how you deliver on initiatives.
That's correct, yeah, I agree.
There is a reasonable amount of money that's already been spent in the Aboriginal justice sector.
Yes.
Do you agree with that?
Yes.
Do you find that there's any resentment from other sectors of government about that expenditure?
No. Not from my experience, no.
So that in the event that there is a need for increased expenditure, there's no impediment that you currently see coming from other agencies in competition for those dollars?
So no, I mean, other than that there is a finite amount of money, I think a lot of the conversations that we have with the Department of Treasury and Finance is, and I just use the sort of the economic basis, is that much of the investment actually, early intervention and prevention actually saves money for government in the longer term.
There has been a considerable amount of work done about the investment in early intervention, and popular media have picked up the term justice reinvestment. It's formed part of the federal
Yes.
policy. So that properly carried out with community control, the idea is that money is saved for the government if it invested in the right place.
Yes, that's right.
The difficulty, though, with that that form of economic analysis is that you need to find the money in the first place to provide for those early interventions, and there's a great deal of pressure to do it within budget, I imagine.
Yes, there is. There is an early intervention program within government at the moment. It's in its infancy. That does provide for upfront funding and then reinvestment once returns and gains are made, but that is in its infancy.
Yes, well, I just clarify that the discussions I'm talking about, the competition for resources is as between departments. I'm not talking about the decisions that cabinet ministers may have to make about budget allocations, but
Yes.
the competition between departments. You're involved in the government response to the Royal Commission into Victoria's mental health system.
Yes, I was.
You would have taken some close interest in the proposition that the new system be funded by a new levy.
Yes.
As an economist, I imagine that would have been something that you were quite interested in.
Yes, so it's where you raise a contribution from the public for the specific purpose of rebuilding the mental health system.
And can you just explain to the commissioners what that reform proposal involved in terms of raising the funds?
Yes, so the government has raised monies from the public and through legislation has essentially, it's called hypothecation, so siphoned that particular bundle of monies for a specific purpose, and the rules and governance within that fund, it cannot be used for anything else. So it must be for mental health system, service, infrastructure, and that was, given the huge task of rebuilding the mental health system, that was seen as needed.
And it's not a usual form of funding reform, is it? Hypothecation from new revenue?
No, it's not. The only other experience I've had with it is in the days in the Environment Department. We have an environmental contribution, which is a levy on water bills that then go to the restoration of rivers and riparian areas and environment. Yeah.
Now, is this area of justice reform involving the reduction of over-incarceration of Aboriginal people the sort of area that might invite hypothecation of a new form of revenue to fund the very significant work that needs to be done?
It is an option. It's obviously a government decision as to how that happens, but treaty is the forum whereby two equal parties could negotiate that.
We'll come to treaty. It's a little bit further on, but certainly, as a departmental officer and not as the treasurer, you accept that that type of revenue raising to meet a pressing demand in terms of the reform of the justice system is not something that's out of all contention.
No, it's not out of all contention. I do note that the Family Violence Royal Commission, that reform was done within appropriation. So it is an option, not always for, it depends on what government thinks, but it's absolutely part of a policy lever and a financial lever open to government.
Thank you. Now, in section 6 of the response, the issue of deaths in custody is addressed. At paragraph 202, yes?
Yes.
At paragraph 202, the response notes that 5 Aboriginal people have died in custody in Victoria since January 2020.
That's correct.
This number represents a peak in deaths in custody frequency in Victoria, doesn't it?
It does. It does.
In terms of the number over a short period of time.
Yes.
This year's coroner's report into the death of Veronica Nelson included a scathing assessment of the Bail Act Amendment of 2018. You agree with that?
Yes, I do.
And the coroner also strongly criticised the healthcare provided to prisoners. You agree with that?
Yes.
And yesterday, the government released its response to that coroner's report.
Yes, it did.
I'll come back to that report. In response to the Royal Commission into Aboriginal and Islander deaths in custody recommendations generally, the departmental response notes that the programs that are being undertaken, and refers at paragraph 214 to the evaluation of the Aboriginal Justice Agreement 3 in 2018. That's the evaluation you mentioned a short time ago.
Yes, that's right.
It speaks of the AJA, Aboriginal Justice Agreement process, having reached a level of maturation not seen elsewhere. Can you see that?
Yes.
But that evaluation has to be viewed in light of the fact that it occurred in the same year as the Bail Act amendments occurred.
Yes.
So even though the evaluation notes that the process is reaching a level of sophistication through continued participation, there has to be some question as to its efficacy. If a program of Aboriginal justice that has been in existence for some 18 years at that point cannot divert the government from passing laws which everybody told it would increase the rate of Aboriginal people on remand.
I agree with that. The Aboriginal Justice Agreement and the Aboriginal Justice Forum and Caucus are vitally important. I've been in this role for 4 months. I've chaired 2 Aboriginal Justice Caucuses, and hearing directly from community is really powerful. But having said that, the last AJC, the message was clear that there's a lot of listening, but more action is needed.
Can I suggest to you that they've been saying that for a long time?
Yes, I would accept that.
And so how would you say to the commissioners that your role is going to be different to your predecessors?
I think that the government's reforms in terms of bail and also the minimum age of criminal responsibility, which we will get to, and other reforms, there is, and this is, and I'll say engagement and consultation, but there is a true engagement, and that is happening now with the Bail Reform Acts, with the AJC, as well as Aboriginal stakeholders and Aboriginal service providers to truly understand the impact. And my job and the job of my department is to provide that advice back to government, to say this is the advice of the AJC, of VALS, of JIRA, and assess those and provide that information to government, and government will then make that decision. So it is It is not self-determination, but it is a true and real and genuine engagement and partnership.
Ms Houghton, can I suggest that there have been so many reports over so long that have said exactly the same thing. How is this any different? And how will we get a different outcome?
Well, I think the fact that bail reform and the minimum age of criminal responsibility is on the government's agenda is part to the continued advocacy of all of Aboriginal people. So whilst that's not answering your question, because there has been a lot of inquiries and reports, action is being taken in these two very significant policy realms that will make a difference to Aboriginal Victorians.
But as Mr McAvoy said, you've heard this from the Aboriginal Justice Forum again and again and again. I'm sure, what is it, 18 years that they've been going now?
23.
23.
It was 18 in 2018.
Okay, so it's 23 now, and we have bigger and more issues, let alone those deaths in custody that Mr McAvoy just, and you've mentioned in here. So tell me how you take their advice.
So we would take, so for example, if I could use bail reform as an example, so the government has committed to bail reform in this year, and the department is consulting on various aspects of bail reform and sitting down and talking with Aboriginal Justice Caucus, VALS, JIRA and other stakeholders within the justice system. The views of all of those people will be then provided to particularly the Attorney and the other Justice Ministers, and options and understanding of the impact and that analysis will be provided in a submission to Cabinet, and Cabinet and then Government would make that decision.
If we're talking about bail reform, then that would have been the process before that Act was about. If the law changed with bail reform,
Yes.
you would have received a lot of input from the caucus, am I correct?
In terms of the 2018?
Yes.
So 2018 bail reform, again, was caused by Burke Street.
Yeah, no, that's not
And
what
then-
I'm asking.
but then-
I'm asking about the information to
Yes.
know that there would impact
Yes.
adversely
Yes.
on Aboriginal people and have more of an open representation. So,
Yes.
if we went back and looked at all their minutes, I'm sure they advised all of those people you're talking about, JIRA, the
Yes.
caucus,
Yes.
VALS, would have advised
Yes.
that this is the impact it's going to have on Aboriginal people.
That's correct. And Justice Coghlan did that review of the Bail Act, and those views were I'm not sure who provided that consultation, but there are a number of meetings and submissions into that. So the
So they
impact
weren't
would have
listened
been
to.
there.
They weren't listened to, really. So we've got guided by self-determination, but it's not really self-determination. So you get to decide if you take it or not. And so the blood of Aboriginal people that die in custody is on the state because you don't take that advice, would you?
So the role of the public service is to provide that advice, and the decision-making occurs within government, and then the public service implements the government's decisions.
So they decided not to take that advice.
So the government had an objective of community safety at that time, and the balance, as they admit now, was wrong.
So they knew that it would adversely affect
Yes.
Aboriginal people.
Yes.
It's not, if I can just
Yes,
interrupt Commissioner Hunter, it's not disputed that the government were advised prior to the 2018 bail amendments that Aboriginal advocacy groups and the caucus were saying this will be the effect of these amendments.
That's not disputed, no.
No. It's a difficult question, but I ask you if it's then fair to assume that the Aboriginal community in Victoria can have all the programs and advisory groups it likes. If there is a government imperative to push through legislation, then those programs and advocacy groups may have no effect in protecting Aboriginal people from further gross systemic incarceration.
So I think that the weight of particularly the legislative reforms definitely outweighed the impacts of the many programs and advices that government received.
We know that you weren't the Secretary of the Department at that point, but the submissions that we've received, this Commission has received from the various Indigenous advocacy groups, indicate that the reforms that they were recommending to government, the changes to the amendment bill, which would have mediated the effect substantially, were ignored, and they were only small changes, and it could have been done. But what happened is that the political imperative outweighed everything else, and that's the proposition I'm putting to you, that at the end of the day, we can put in place all of these structures, but self-determination falls by the wayside when there's a political imperative.
So I won't talk to a political imperative.
I won't press the question. I want to give you the chance, both of you the chance, to indicate to the commissioners how you think, with all of your experience in the bureaucracy, how do Aboriginal people in Victoria protect themselves against disasters like the 2018 Bail Act Amendment? How can they do it in this current environment?
So I think the ultimate process and is treaty in how the accountabilities and governance and roles and responsibilities within government may change. In the meantime, I think the clarity of Aboriginal impact could be stronger into government processes, and having a direct voice into the government processes, either through, and I know that you've commented on Aboriginal impact statement or assessment, but within the current sort of process and template, that is not hardwired into the current sort of template by which government receives advice. So that is a small step before treaty to ensure impact is clear.
One of the recommendations of which we have heard evidence in this Royal Commission, the Commissioners have heard evidence, is a call for an Aboriginal Justice Commissioner or an Aboriginal Social Justice Commissioner. You've nodded your head. Is that acknowledgement that you've heard that discussion before?
Yes, I have heard that discussion before through my short time as Secretary, that the Aboriginal Justice Caucus continues to seek an Aboriginal Social Justice Commissioner.
You see, one of the things that is obvious to the observers of this particular process is that the act of being able to call bureaucrats such as yourselves and ministers to come and give evidence has prompted action. Is there a case to be made for some body that has coercive powers and can call people such as yourself to give evidence in real time about the progress and the development of reform?
So I think it is an option, and it's definitely an option. There are a range of existing bodies that do that, clearly not with an Aboriginal specific purpose, but the Ombudsman, IBAC, the Commissioner for Children and Young People. So there are an array of existing accountabilities that can cause for public servants and ministers to be accountable to progress. But having said that, the Aboriginal Justice Commissioner is an option. I think through the lens of treaty, it would need to be within the broader change and restructure of accountabilities in government if that was negotiated.
Do you see the value in that such a position having coercive powers to call witnesses and to call for production of documents?
I see accountability for the public servant, for the public service as a good thing, and if coercive powers is one way to do it, there are other ways for public servants to be accountable. That is sort of at the one area of the spectrum. So I don't disagree with it. Accountability is something that I, as a secretary, need to live by.
Chair, should we take a short break for Commissioner Lovett? It might be a suitable time.
Yes, shall we? 5-10 minutes?
Well, this witness has been going for almost an hour and a half. Perhaps we can take a bit of a longer break,
Right.
if that's suitable to the Commission.
Where does lunch fit in? It's 12:15.
It's 12:22.
12:22.
Yeah, so...
You want to take an hour lunch now and come back at 12:30?
3/4 an hour.
Let me just confer.
3/4 an hour, no longer.
In the interest of trying to ensure that we get through this afternoon's witness, I might continue, Commissioners. I see now that Commissioner Lovett has returned.
Ask a question. I'm just struck. I mean, you would agree, and I think we've seen that this is the 2018 bail reforms were a policy failure of monumental size for Aboriginal people in Victoria, First Peoples in Victoria. And the impact is being felt daily. We've met all these people in prison in recent times. We know what it's done to their lives, the lives of their children. I'm just struck by the lack of urgency to do something about it, that we seem to be going and collecting the same information from the same groups that have given their advice repeatedly, and even more worried that looking to treaty, does that mean that this continues for another 5-10 years? Where is the urgency to do something here?
With the Bail Act reforms, the government is committed to introducing and passing the legislation this year. Whilst I know 2008 to 2023 is a long time and the impact is real and present, the commitment is this year to change the bail reforms and the impact for people that have minor offending.
Do you understand this affects people's lives in the fact that they lose jobs?
I do.
They lose housing. They lose their kids. While they're sitting for their average 30-something days, crimes of poverty to feed their kids. We've heard the women directly talking to us. And then whilst they're in there, they receive minimal care of health. Minimal. Some of them can't even get to see a psychologist, let alone health, with the amount of teeth problems in there. Yet they've got to stay in there for 38 days because they tried to feed their kids, and it's not urgent. I suggest that you go in and talk to these women to understand how urgent it is, because they're the ones that are living this reality whilst we're waiting for a couple more years. Do you know how scared they are of another death in custody? They are petrified that the next one may be them. So whilst we're waiting, again and longer, we have these women that are put under monumental stress that can't even get bailed to somewhere because there's nowhere to go. It's urgent.
Thank you, Commissioner. Just Looking at the scenario in Victoria a little more broadly, the question strikes us that how does the state of Victoria move from the current prevailing circumstances with all of the disadvantages that you've spoken of at the beginning of your evidence to one in which Aboriginal health and well-being is as good as or better than the surrounding population? How does that happen? I mean, do you believe that it's even possible for a dispossessed people in a former colony where the descendants of the colonials are still in power and their access to land and resources remains dependent upon their continued dispossession as First Peoples? Do you think it's even possible for the Aboriginal people in Victoria to reach some level of parity with the rest of the population?
I think it is possible. I think as a senior public servant, I need to think it's possible because that is a core purpose of my job. And the work of the Yoorrook Justice Commission, coupled by the treaty negotiations, is that the shift, not just incremental reform, it is the shift that provides that ability to change.
There's one further aspect of the death in custody area that I want to ask you a question about, and it's closely related to the question and comments from Commissioner Hunter. Now, where the Commission is aware that your department has a number of Aboriginal employees and senior Aboriginal employees.
Yes.
But I don't know that it's clear that the department as a collective has an appreciation of the profound loss that is felt by the whole Aboriginal community every time there is a death in custody. I mean, how is this something that the government department can have a true appreciation for? Is there something that you can tell the commissioners about how the department, particularly the non-Aboriginal members of the department, are able to empathise and understand those circumstances?
Yes. So I do think it starts with the leadership of the department, and my Board of Management has 2 Aboriginal people as Deputy Secretaries, so the leadership is reflected with Aboriginal people. One of those positions is a designated Aboriginal role, and that's the Deputy Secretary of Aboriginal Justice. So just reflecting from a leadership perspective, but it's also in our actions. I had, through invitation of Auntie Donna Nelson, the ability to apologise directly to her for the death of her daughter, and express my deep sorrow and regret, and that of the departments, of not just her passing, Veronica's passing, but how she died. So that power of Auntie Donna in her advocacy for her daughter, I took that away with me and spoke to the board, and the board will speak to their staff. So in that story, that's just one example, in that storytelling of why it is so important for the department, A, to take accountability, because that is the clear message that I got from Auntie Donna Nelson, is in terms of accountability, but also to see her and then having that storytelling back to the department. That is one way. The other way, in terms of the 4 months that I've been in the department, is through understanding the culture of the department. And so we're undertaking a People Matters survey, and through that, understanding the experiences and the culture of our own department, because then we can really target what we need to do for our workforce.
Thank you. The Commissioners, as you may know, heard evidence from Auntie Donna. Some of the observations that I will make to you at this point about the understanding of the impact on members of the Aboriginal community when there is a death in custody are things that it's not clear to me would be picked up in the processes that you undertake, but I'll give you the opportunity to respond. One of the most obvious impacts is that whenever there is a death in custody of an Aboriginal person, it triggers trauma for the whole community. Now, how does the government's training and education pick that up? Is that something that's discussed?
So there is formal cultural awareness training. It is mandatory for certain positions, but it is voluntary for the general Victorian public service within the department. And that goes through the understanding of trying to seek understanding of the impact of colonisation and the disadvantage and impacts from events such as a death in custody.
Is there an understanding in the department that for Aboriginal people, the loss of somebody to a death in custody might be seen as the loss of someone to the people who stole their land?
I would say not acutely.
Or that the loss of somebody, passing of somebody in custody is the continuation of a 5-year process of killing Aboriginal people?
Probably not acutely, but yeah.
Or that there is immediate suspicion that there is some form of foul play and that the government is covering up for its own. That must be understood. It was heavily ventilated in the coroner's inquiry into the death of Auntie Tanya Day.
I think from the consciousness of the department, they would have an understanding that of the impact to community, the specifics of that. I couldn't say that it was an acute awareness, no.
Or that people feel immediately fearful for their own safety and the safety of their own family.
Yes.
When they see how easily the lives of others are taken. Do you think having that appreciation of the impacts might assist departmental officers in carrying out their work?
Yes, it would.
How does the department ensure that not only does it engage in compulsory cultural awareness training, but develops in its staff a deep understanding of what the consequences of government action and inaction are on the first people of this state?
I think it is absolutely something that I can take away and seek advice from Aboriginal people as to how that can be done, and I think you raise a really important avenue for action.
Excuse me, Ms Houghton, can you tell me the current cultural awareness training is
Yes.
not mandatory? How long is it and how is it assessed?
So there's a range of cultural safety training depending on what position you take within the department. So I'll just get the specifics. So it's mandatory for all prison officers and youth justice workers, justices of the peace and bail justices. The evaluation for corrections, for example, is post-training survey. For bail justice evaluation, which Marian might wish to talk to, one of the things in preparing for this witness hearing is that there are surveys, but there's also a data point, and this is to happen in 2023, between the correlation between the training and remand rates. So that data-driven, the training's been here, has that changed decision-making, what data point is there for correlation? In terms of, I do have information which I can get to you in terms of how long it takes. I think it's either from 3 hours to a whole day, and the evaluation is varied.
But is there any requisite training or qualification that somebody must have to show that they are fully across Aboriginal perspectives and the position of Aboriginal people in Victoria before they can get these jobs?
So for police officers, it's pre-service, so before you go into the job. For youth justice workers, in the Certificate 4 of Youth Justice, there is a compulsory module on cultural safety. It's called Culturally Strong and Safe. So that's part of the Cert 4. So it is varied depending on your position.
A lot of people within the criminal justice system, they will have had between 3 hours and 1 day.
Correct. As public servants that don't have a direct operational role.
Do you think that's adequate?
I take the point that it may not be adequate, but picking up that it's voluntary, and I think actually making it compulsory, a mandatory part of our training is something that I will take back and think about in our department.
Thank you. Now going to move to some areas of discrete criminal justice reform. You've covered these areas in some detail in the departmental response. The first issue that I want to take you to is public intoxication. The government passed the Summary Offences Amendment Decriminalisation of Public Drunkenness Act in February 2021. That's correct? It's still not yet been commenced.
That's correct. There was a decision and a change of the commencement date to 7th of November of this year, 2023.
Now, we will get to the reasons for that, but it has taken some 34 years since the Law Reform Commission report in 1989, which recommended the abolition of public drunkenness as an offence, and some 32 years since the Royal Commission into Aboriginal Deaths in Custody report to look like the government's delivering on this reform. It hasn't quite delivered yet. And in your response, your written response to the questions of the Commission, you note at paragraph 253 that in the Royal Commission into Aboriginal Deaths in Custody, all 3 of the deaths that were investigated in Victoria, of the 99 deaths, were for people who were only in custody for public drunkenness.
That's correct.
One of them was Auntie Tanya Day's uncle, Harrison Day.
Yes, that's correct.
Ms. Houghton, in 2020 you were the Deputy Secretary for the Social Policy Group,
Yes, that's correct.
DPC. Who was your minister in relation to the public drunkenness legislation, the Summary Offences Act?
My minister in the Department of Premier and Cabinet was the Premier.
And you had the responsibility for briefing the Premier on all social policy matters that that might go to Cabinet.
That's correct.
The social policy matters that might come before you whilst you're in that position included public drunkenness, raising the the minimum age of criminal responsibility. Was that one of them?
So yes.
I'm not asking you whether you briefed on it, but it's a matter that came before you to your attention.
The reason public intoxication in terms of, so the Department of Premier and Cabinet provides briefs to the Premier on issues, all issues that go to Cabinet and Cabinet committees. In that time, public intoxication was one of those. It obviously went to Cabinet. Government had made a decision. The age of minimum criminal responsibility was a policy issue that was discussed across government. I just can't recall in terms of briefing Premier on that particular issue, but yeah.
I propose to ask you a couple of questions on the public drunkenness topic. In fulfilling your role as the Deputy Secretary and ensuring that there's all the appropriate information is gathered in, it was necessary for you to ensure that you understood the position of the stakeholders in relation to that reform?
Yes.
And by the position of those stakeholders, I mean who supported the reform and who opposed it.
Yes.
I'm talking in a general sense now. Coming to the public drunkenness reform, do you remember which stakeholders at the time supported that reform? I know it's a bit of an ask, it's a few years back, but it was a significant piece of reform, wasn't it?
Yes, it was, and the expert.
Sorry, Phil, I could just ask you to stop. I thank my learned friend. By reference to stakeholders, I mean non-government stakeholders.
Yeah.
You could please continue.
Yeah, thank you. So the expert reference group, which was coordinated by the Department of Justice Community Safety at the time, it had a range of stakeholders on it, and they provided advice to government as to what the views of decriminalising public intoxication is, and also the model, the health-led model, to substitute for that to support people from a health-led perspective as opposed to a criminal justice perspective. So from that, Aboriginal stakeholders, Arnie Tanyaday's family, and I just do want to pause and express my regret and sorrow for her death and her passing and how she passed. The AJC, so Aboriginal stakeholders clearly have been calling for this for a long time. And
do you remember any of the non-government stakeholders who opposed the reform? I
recall that the Police Association was worried about the operationalisation of, sorry, I got the word wrong, of removing the criminalisation element of public intoxication.
And you're aware that that's a position that they've continued to ventilate?
I'm aware, and that's through media reports, yes.
But that was, your memory now is that that's the position the Police Association of Victoria was taking?
Yes.
There was an article in the media in 2017, which I'll ask you to assume I'm relaying to you in the correct fashion, positing the question, is the Police Association the most powerful union in Victoria? Do you have any view about that question?
Most powerful. So I think the Police Association has a very strong voice and has a very strong voice in the public. Its influence in terms of government decision-making it is one of many voices in government decision making.
In terms of the opposition to the public drunkenness reform, you would agree that it has been one of the most vocal opponents?
Yes.
And I say opponents in the sense that you've mentioned earlier that they have raised opposition on the basis that they say that they should have some replacement powers.
Yes.
I suggest to you that it's also the case that the Police Association has... Withdraw that. I won't do that. The reform of the Summary Offences Act was due to commence in November 22. Is that correct?
I might get Ms Chapman, if that's okay, she's more familiar with that piece. Yep.
Thank you. Mr. Chapman?
There were reforms considered by government that were delayed due to the COVID pandemic, so they didn't proceed.
Initially, when the Summary Offences Decriminalisation of Public Drunkenness Act was passed in February 2021, the commencement date was identified as 7 November 2022, I think. If I can.
Yep. Yes, that's right.
And the reason that date is easy to remember is that it was the date of the Melbourne Cup that year.
That's correct.
And one can only guess that a point was intended to be made by placing it on that date. I don't want you to respond to that. That commencement date was amended by another piece of legislation last year to now commence in, I believe it's December this year.
It's November 7, yeah.
7 of November.
Yep.
Now, your department has carriage of certain aspects of that reform, yes?
As Department of Justice and Community Safety, yes, yes.
And you're involved with, in discussions with other agencies about the matters that need to be undertaken to ensure that the Act can commence on time?
Yes, that's correct.
And from your perspective, taking into account what your agency has done and your knowledge of other agencies, is the commencement of the repeal provisions in November 2023 on track, or is it something that is suffering some slippage and we might see a further deferral?
So I have had no call or advice that a deferral is needed or warranted, but I do accept that the preparation and readiness for the commencement on the 7th of November is challenged, particularly around setting up the health-led model with sobering services and outreach services. And I see that largely from my perspective around workforce and trying to get the operating model, like the workforce in train and the operating model operating in time for the 7th of November.
Suggest to you that the Police Association has been somewhat critical of this reform. Is it the case that there has been full assistance from the New South Wales Police, the Victorian VicPol, and at an officer level in terms of facilitating the readiness for this commencement?
Yes, Victoria Police, once the decision has been made, they are participating in a range of readiness activities, including training their workforce to work through the operating model.
And the government has established a number of test sites,
Yes, that's correct.
and the data from those test sites is available.
So I think there was one interim report last year, and I think only one trial site was available. There is another report from the evaluation which will come, I think, in September, August or September, to see how ready we are.
It's awfully close to
Yes, it
November in terms of government decision-making and in terms of perhaps any change of direction.
Yes, it is.
I'm not saying change of direction in a negative sense. I'm just saying
Yeah.
tailoring the
Model.
health alternative to meet the needs of the community.
Yes. Yes.
So I think you're suggesting that it's going to be a bit tight.
Yes, I am.
But I take it from your evidence earlier and from what you've heard indeed from the commissioners that you understand the urgency of this particular reform.
Yes, I do.
Ms Houghton, can I just check with you, how likely do you think that there might be a further delay?
Given the, I'm not trying to talk for government, but knowing the appetite of the government to get this done and not introduce legislation to defer again, I think it is highly unlikely.
And to follow up from that, what is the risk of this change being put in place without the requisite and most effective health supports in place? There is the risk that this will then be deemed a failure. I worry that if this, I mean, I most definitely want it on the 7th of November, but if the health response is not in place, then it may be blamed that somehow that it wasn't the right thing to do and we should go back or give police more powers. I just think there's a big risk in this if the health response, and I feel that even though it's the government who is doing this, it'll be Aboriginal people or ACCOs who will cop the blame.
I think my department, the Department of Health, are working as hard as we can to make sure that that risk is as small as it is. And I think this is the balance of it might not be perfect at the beginning, but we continue to improve. But the risk of having public intoxication criminalised is greater than an imperfect model of the health-led model. And I think that's where the government is at.
Can I ask a question just on that? So we've spoken a lot about we've spoken a lot about adults, but how does this work in relation to Aboriginal youth, and children under the age of 18?
So that would be a criminal offence for them. So the response, the health-led response, would be tailored to their age. It still would be an outreach model or a sobering centre to move them there. But from what I understand, the involvement of families, parents, or carers would be involved in how to make safe that child or young person.
So we've spoken about the facilities that people will be taken to. Is there anything for youth? Or have we just concentrated on the adults?
I can't answer that. I think Department of Health would be better to answer that, sorry. But we can endeavour to get you that information.
Yeah, that would be.
Yeah.
Yep.
I now wish to take you to the issue of raising the minimum age of criminal responsibility. Another vexed area of policy and reform. Ms Houghton and Ms Chapman, the commissioners are aware that, because it's the subject of media, that the cabinet decision has been made to raise the age of criminal responsibility. Can you explain for the Commissioners your understanding of the detail of that decision as regards three things: timing, the carve-outs, you understand what I mean by that,
Yes.
and the alternative service model?
Yep. So in terms of, and Marian, we might tag team if that's okay. So in terms of, the government has made a decision to raise the age of minimum criminal responsibility from 10 to 12. They will introduce legislation and make it effective from middle of next year, 2024. 10 to 12 will have no carve-outs. Then from work will be done on, or continue to be done on, an alternative service model, and I'll talk to that in a minute. And then in 2027, subject to the alternative service model and independent review of that, the age will raise to 14.
So the...
Sorry, can I just add, with carve-outs for 14?
And just for the record, by carve-outs, we are both referring to particular offences for which the age of criminal responsibility might be lower.
Correct.
So the numbers of children in the 10 to 12 age group who are in the system is quite low. Is that correct?
Yes, I've got the data for yesterday, 30th of the 4th, and there were no children between 10 and 12.
Well, that's a wonderful figure. Is it? But it's not the case, of course, that that's likely to stay that way indefinitely. But for the moment, it's
Yeah,
a good figure.
it is a good figure.
And do you have the figures for the over 12 and under 14, the 13-year-olds?
So there are
12 and over?
12 and over, 7.
In custody.
In custody, yes.
And do you have figures for the numbers under 12, so 10 and 11-year-olds who have been charged with offences?
So that there are no 10 and 11-year-olds in
In the criminal justice system?
in youth justice at the moment, yes.
Okay. Now,
Can I just be clear about this? Council's question was that whether any 10 and 11-year-olds had been charged but were not in custody.
Oh, sorry, I'm not sure how many are on supervision orders. Yes, sorry. So I'm talking about in custody. Yeah, sorry.
Which leads to my question. It would appear that there has been a concerted attempt by courts and others involved in justice to use non-custodial options for dealing with criminal behaviour by 10 and 11-year-olds. Is that right?
Yes, I think, and the Commissioner for Police can talk to this more in depth, the use of cautioning has become quite a strong, obviously, diversion from
Yes.
the criminal justice system.
Yes, thank you.
now, in terms of the development of the operational support for this reform, does your department have a role?
Yes.
It has a role in the operational as well as the policy and legislative functions?
So it has responsibility for the policy legislative functions, the operation in terms of the alternate service model, if that's what you're referring to. We ourselves and the Department of Families, Fairness and Housing have responsibility to develop, create and operationalise alongside other partners within government.
Are you at liberty to say how far advanced that work on an alternative service model is?
So the departments have been working for a couple of years on what that looks like. In terms of its level of detail, it's not operationally ready. It needs to have consultation, so we have not consulted with people external from government as yet. And the government's decision representing its criticality to raising the age to 14 has an independent review panel alongside that, so that will need to be created as well.
Just so I can be clear on this, because it's placed or in partnership with the Department of Families, Fairness and Housing, can the commissioners take it that the alternative service model is a child welfare model as opposed to, say, an education model or a health model?
Yeah, yes, it is more attuned to providing supports for children and young people, yes.
From a welfare perspective, from a child protection perspective?
Well, the hope of the alternative service model is that it is an alternative to child protection, so it is a support wraparound tailored to intensive or non-intensive for children that could be in the criminal justice system.
Have you had any early discussions about the legislative reform involved?
So the government's, it's a policy position. The drafting of legislation is the next step.
Without going into too much detail, it would seem that at the very least, raising the minimum age to 12 with no carve-outs would not be a difficult legislative reform measure.
No, but I'll go to Marian, who will be drafting the legislation.
By itself, just that raise, that's correct. One of the other reforms that government's committed to is to strengthen and codify the Dolly Incopax principle. So that also plays into the age at which a child can be found competent to have engaged in criminal behaviour. And that's a common law presumption, which the commissioners may be well informed about, that generally a child under the age of 14 can't be presumed to have criminal capacity. So that's a safeguarding test.
Thank you. Is there any intention to raise or to change the common law presumption as to age at which the presumption of Dolly Incopax might be applied?
Not in relation to the age, but it's more around strengthening the application. So there is inconsistent application of that principle. It applies across all of the common law jurisdictions. And one of the concerns, of course, is if a child is asked, do they understand what they've done wrong? Some children like to answer yes to that without necessarily understanding the consequences of what that answer might be. So that's one of the reasons that it's been decided by government to codify and strengthen that.
And indeed, that's one of the underlying features of the whole Raising the Age campaign, is that whilst that children may not understand or adequately appreciate the consequences of what they do, even though they may have some understanding of what they've done. Do you agree with that?
I do agree with that.
Information?
Yes.
Counsel, can I just check whether we should take a break? I'm mindful of the time and our afternoon program.
I can indicate, Commissioners, that I've probably got another 30 minutes. I have checked with my learned junior, Mr. Goodwin, about the witness for this afternoon, Ms. Hopkins, Dr. Hopkins. He has informed me that we can continue into the hearing time this afternoon if the witnesses are available after lunch, and that he'll still have time to take the evidence of Dr. Hopkins. I understand from Mr. Gray that the witnesses are available for the whole of the day, but we just might confirm that.
Yes.
Yes. I think we should have a break. I think we should have a break. Half an hour or
Oh, I don't think that's long enough for people to refresh.
Okay.
Should be an
1
hour.
hour? 1 hour, then thank you.
Thank you.
Back at 2, we'll adjourn
So
until 2.
if we're 2 o'clock.
Yes.
Thank you, Chair. Yes, I think everybody's ready, Commissioner.
Thank you. Have we got sound?
Yes.
It's good. Yep.
Commissioners, I'm going to resume with the examination of Ms. Houghton and Ms. Chapman. Before the break, I was asking you some questions about the policy reform in relation to the minimum age of criminal responsibility. We were talking about the role of the department and the potential for some slippage. One question I didn't ask you was whether you were able to tell the commissioners if there was any budget attached to the decision. Yes?
So there was no budget attached to the decision at the time that the decision was announced. The government's obviously still going through its budget considerations for the May 2023 budget, so I'm not aware if there is any further budget considerations from that.
And the commissioners can expect to know, along with everybody else, once the budget's handed down.
Yes, that's correct. And I think within the development of an alternative service model, there is still development to come, and any operational funding would probably be at a later budget, but we'll just see what the budget says at the time that it comes down.
Thank you. I just wanted to ask you whether in your understanding of the relationship between your predecessor and the Aboriginal Justice Forum, you have some knowledge of their meetings?
So the former secretary? I have knowledge that the former secretary would have been a co-chair at the Justice Forum, yes.
Do you know whether there was any expression of a preferred minimum age of criminal responsibility from the Aboriginal Justice Forum to your predecessor?
To the predecessor, no, I'm not aware.
Do you have any knowledge of what the Aboriginal Justice Forum says is the appropriate minimum age of criminal responsibility?
Yes, the forum and caucus have made it aware to me that their preferred age is 14 years of age.
And I take it since the decision's been a fairly recent one, there hasn't been a further meeting with caucus or the forum?
That's correct.
But at that meeting, the decision, I suspect, will be a topic of discussion.
Yes, it will.
It's fair to expect that there will be concern expressed about the delay in raising the age to 14. But,
I suspect consistent with their position that there would be concern.
Their position has been strongly in favour of raising the age to 14, hasn't it?
Yes, it has.
Okay, I just want to ask you now some more direct questions, I suppose, about bail reform. It's known that the Bail Act disproportionately, the amendment of the Bail Act disproportionately affected Aboriginal people. You've covered that. Do you accept that that there would have been a compounding effect of the provisions of the 2018 bail reform, which results in an unequal effect, inequal effect on Aboriginal people?
Yes, I do.
And in part, that's because of the known racial profiling and over-policing. Would you accept that?
I don't know of that in terms of over-policing, but I answered yes because of the social and economic disadvantage of Aboriginal people. It is more likely through the bail reforms to include and capture people, vulnerable people, Aboriginal people within the architecture of those bail reforms. Over-policing, I don't personally know enough about that to say yes or no to that. It may be true, it may not be. I myself can't answer with any sort of knowledge to that.
You're aware, though, that there were proceedings against the Victorian Police in the 2012, 2013 in relation to racial profiling?
I'm not, sorry, no.
Okay. In relation to the Bail Act, and I'm talking about the post-2018 form of the Bail Act, are you aware of whether you or any of your predecessors have obtained legal advice to the effect that there may be some infringement of fundamental human rights or a breach of the Victorian Charter of Rights?
I'm not aware of that myself, that a former secretary has sought that and received that.
And you haven't sought that advice yourself?
No, I haven't.
You're familiar with Section 3A of the Bail Act?
Yes, I am.
And you're aware of the criticisms from the coroner?
Yes, I am.
And the Veronica Nelson inquest about the lack of understanding and the incorrect application?
Yes.
Section 3A of the Bail Act. Can you just explain for the commissioners, and I know some of it's in the public already, what steps have been taken to remedy those failings?
May I pass to Ms Chapman on that?
Absolutely.
Thank you.
Yes, as part of the bail reforms, we're looking at strengthening Section 3A. That will be to include a wider list of characteristics that can be taken into account. That's following discussions with the Aboriginal Justice Caucus, and also looking at the training for bail justices in how they make bail decisions. So that's within the purview of the department.
Can you talk to more broadly around the word characteristics? What do you mean by that, please?
Yes.
Thank you.
Sorry, Commissioner, I think I've used the wrong technical word. I'm talking about the list of factors that can be taken into account under Section 3AAA.
Yeah, so can we talk to what those factors are, please?
Their considerations currently, the legislation requires consideration of cultural background, ties to extended family or ties to place, and that's the current list. That will be expanded, as I said, following an additional considerations that have been given to the department from the AJC.
Can you talk a little bit about the training? Because as council has just said, it's that section has not been applied properly and it's been misrecognised perhaps, and it hasn't actually worked to do what it was intended to do. How will things change? How will we not just get a repeat of the same thing but with more factors being ignored?
Thank you, Commissioner. I can talk to the training, cultural awareness training that's being provided to bail justices. And as you know...
Hours?
4.
4? Okay.
This is the most recent training, and it's been provided between October and now. And my understanding as of today is that all bail justices other than 2 have completed that training.
How will you monitor the Section 3A is being implemented properly? Because it doesn't seem to have been any monitoring of the failure of that clause to have any effect.
Yeah. We are going to evaluate the cultural awareness training. That hasn't started yet because the training hadn't been delivered to all of the bail justices. So that will be done from July. We do want to consult with caucus and Aboriginal stakeholders about some ideas about the best way to measure that and to look at whether or not there is actually a correlation in the drop of numbers.
That's what I'm looking for.
Yeah.
How is that delivered? Online? Is it like a module?
The most recent one was online, so it was delivered by Tarina Fanning, who, as you may know, Commissioner, delivers cultural awareness training to other justice partners and has delivered training to bail justices in the past, so most recently in 2018.
Given the importance of it, wouldn't it quantify doing it in person? I mean, I know it costs more resources to, move people around to be able to attend training, but given the importance of the topic, and the detriment that it has happened to our people because of that, surely it could be in person.
I'm happy to come back. I'm not sure why it was delivered online. I do know that 2018 was delivered in person and was in Metro and Regional Victoria. So I'm not sure if it was a cost factor or a time factor, but I can certainly find that out and come back.
Final question, that 2018 training, was that ever evaluated as how effective was it? There was the correlation in number of Aboriginal people being granted bail?
No, it wasn't evaluated in that sense. Feedback was sought from the facilitator. I understand the facilitator may have contacted Victorian Aboriginal Legal Service and JIRA, but I'm not sure if there was a response provided. But my understanding is that that was the extent of that.
Hopefully that evaluation will be available to us so that we can look maybe in 12 months' time to see, while the Commission is still running, to make sure that
I think we're very comfortable to do that, yes.
That was mandatory, wasn't it? I may have missed that. Was that mandatory?
Yes, it was, Commissioner. So it's mandated under Section 23 of the Honorary Justices Act.
In terms of strengthening Section 3A, the provision is highly generalised and talks of issues that arise due to the person's Aboriginality, including some other general considerations. Is thought being given to making this more specific about what aspects of Aboriginality may bear on the bail decision?
Yeah, that may be part of it, Commissioner. It is part of the consultation that we're going through at the moment, so I don't have a landed position. But obviously we really want to understand the views of all of the stakeholders about how we can strengthen it and other steps the department can take in a wider cultural awareness setting. And that includes the department's role in the recruitment of magistrates.
Yes.
So that's something we've been talking about and discussing with the attorney as to how we can look at cultural awareness understanding in the pool of applicants before they're appointed.
Well, certainly the provision in its present general terms asks a lot of the judge or magistrate or justice applying it if it's to work effectively. I'm familiar with this provision and the way in which it is sometimes well applied and how very often it is not. And what you will see if research is done is frequent tick-the-box application. Because it is mandatory, one finds I take into account Section 3A, but very seldom are the relevant cultural factors, the obligations, the kinship matters, those things which bear upon whether about the impact of not granting bail on the individual and their family taken into account in any detailed way. So I would want to stress the need to look into the text of the provision in the strengthening process, and also emphasise the need for significant upscaling of cultural awareness among those applying the provision and also those appearing as advocates in court seeking to deal with the provision.
Yes. So we've been thinking internally in its early stages, as I said, because how far you can strengthen it is still being discussed. But discussions with the legal regulators that we've just talked about internally, we haven't reached out to them yet to say, is there a strengthening of training that can be provided to lawyers in general? I do know VALS, JIRA, Victoria Legal Aid, community legal centres do that and often do it really well, but it is not as widespread as it could be. So we're very conscious of that. I also note the Judicial College, which provides training to sitting judicial members, does have resources on Section 3A and some analysis available. So we would also be talking to the courts, but the training of sitting judicial members is, as you would know, a matter for the courts.
Thank you. The training provided by the Judicial College, though, is not mandatory, is it?
I don't know the answer to that, I'm afraid, but I can find out.
not.
I believe it's voluntary.
And I'll tell you this, during the course of evidence in previous hearing blocks, we heard from agencies, community legal services and solicitors' practices where each of the witnesses expressed concern that magistrates in particular often did not understand or correctly apply Section 3 A. And it raises a concern as to both the training, but secondly, whether there's any scope for making completion of that training a prerequisite for allocation to courts in areas where there's a high volume of Aboriginal users, if I can put it that way. Is that something that's being considered in the department?
So the department does not have levers to determine the allocation of judges. That's a matter for the head of jurisdiction. But certainly I'm happy to have discussions with the Chief Magistrate just to have a better understanding of what the current practice in the Magistrates Court is for training. We do meet with the heads of jurisdiction frequently. We consult with them. We're consulting with them on bail reform. And so they are a very important part of any changes to Section 3A.
Thank you. I'd like to now direct your attention to paragraphs 286 and 287 of the departmental response. And I'd invite you, Ms. Houghton, to read those two paragraphs. They're a little bit lengthy, but...
So paragraph 286. Paragraph 286. Imprisonment disrupts many of the factors that mitigate against offending behaviour, such as connection to culture and country, accommodation, employment, and positive relationships with friends, family, and community. This means that when released from remand or a short sentence, people can be more likely to offend than they would have been prior to imprisonment. People on remand and serving short sentences can also be volatile than people serving longer sentences, as they have less time to adjust to the prison environment. As a proportion of people on remand or serving short sentences increases comparative to people serving longer sentences, the level of instability across the system may also arise. Paragraph 287, DJCS recognises the distinct impact of increasing remand rates on Aboriginal women. These typically short stays in prison can have significant impacts, including potential loss of custody or access to children, impacts on wellbeing, loss of housing, income and employment supports, and disruption to education and connection with community and support services.
Thank you. I'll make this observation that it is well and good to recognise the particular impact on women, but can you explain for the Commissioners what is being done to address this particular problem as far as Aboriginal women are concerned and the growing rate of incarceration?
So there are a number of programs, and I can reference them in terms of helping women whilst they're in prison, in terms of in terms of once they are released from prison to connect back into family. There just are a number that, and largely through the AJA and AJC, that those programs are there. In terms of structural or legislative, I can't recall or bring to your attention anything that would assist Aboriginal women in that regard.
Is it your view that more could be done in this area?
Yes, definitely.
We did hear from women in prison just a couple of weeks ago that even those programs that are available are very, very hard to get into, and many of the women did not know they were available.
Okay.
So whatever's happening at the moment, it certainly isn't enough.
Yes, yes, and we may get to it later in the hearing. In terms of the health provision, particularly in Dame Phyllis Frost and Tarrangower, that there has been moves from 1 July this year to improve the health services provided, particularly to women and Aboriginal men. So that is, and that directly relates to the coroner's findings from the passing of Veronica Nelson, but we might get to that at some stage.
I might make another observation that the Commissioners understand that there are a substantial number of Koori courts and youth Koori courts in operation. And this in some way addresses the need for better sentencing practices. In addition to this, the government is supporting the use of Gladue-style reports, which are being prepared by the Victorian Aboriginal Legal Service.
Yes.
That's a pilot program, I understand. Is the impact of that particular initiative being monitored, and is it something that you can speak to in terms of the likelihood that it can be expanded?
Ms Chapman will address that.
So that's a current project the Victorian Aboriginal Legal Service is undertaking. They're going to produce 20 reports that are modelled on that Gladue-style report. That comes from a Canadian structure, as you may know, and it's intended to promote a better understanding of the underlying causes of offending, including historic and cultural context of an offender. At the moment, there does need to be adaptation of that for a Victorian context in those reports. We haven't received those reports as yet, but we're looking forward to having receipt of them and talking further with Vals about what the learnings are from that pilot.
So what are the timeframes? What are the timeframes? When did it start and when does the trial finish?
Sorry, Commissioner, I don't have that information, but I'll come back with it.
We have had some, I can tell you that we have had some evidence on those reports and that program from Ms. Waite of Vals. I just want to take you now, unless there are any further questions on that area from the Commissioners, take you now to the issue of independent oversight of the police service. The Attorney-General has responsibility for the Independent Broad-Based Anti-Corruption Commission
Yes.
and the Victorian Ombudsman.
Yes.
And you're aware that there's been evidence in these hearings that has been very critical of the present system of internal review of complaints by Victoria Police Service,
Yes.
and many calls for external police oversight.
Yes.
You're aware of that?
Yes.
It's been a subject of discussion in the Aboriginal Justice Forum,
Yes.
and you can understand why that might be, that people are advocating very strongly for an independent oversight.
Yes, I can.
Because one of the reasons for that is that it appears from the evidence that this commission's heard that very few people in the Aboriginal community have any faith in the complaint system, and that it's resulting in people not making complaints because they don't expect that the complaint will be adequately dealt with.
I understand.
So if we put to one side the IBAC review from last year, which you're familiar,
Yes.
I just want to talk to you from a governance perspective. As a person that's been in governance, in government for some time, who's a recipient of the PSM award, and somebody of your experience, Ms. Chapman, as a matter of good governance, the continuation of an internal complaint mechanism is something that's really outdated in this day and age, isn't it?
I think that the current system of police investigating itself, even through the Professional Services Command, through the range of reports and just the data that I understand in terms of substantiated reports, would suggest that governance would need to change.
But as a general proposition, in government, people are very rarely able to investigate their own in terms of complaints. It's usually done on an external basis.
Yes, that's the case, yes.
And I might just take you to some examples. In the health sector complaints against practitioners are handled externally to the profession and the department. They're handled by the Health Complaints Commission.
Yes, and Safer Care Victoria also does.
And legal practitioners. Complaints against legal practitioners are handled externally through the Legal Services Commission.
Yes.
And complaints against judges. They're handled externally, aren't they?
Yes, they are.
Through the Judicial Commission.
Yes.
And in each of those areas of practice, there's highly technical aspects to it. Yet these external bodies seem to be wholly capable of making decisions about whether conduct is appropriate or not. And on an objective basis, would you agree that there's no practical reason why external independent oversight of Victorian police misconduct could not be established?
I might answer that one, if that's all right, Mr McAvoy. In Victoria, we do, for external police oversight, we do have a mixed civilian model, which is a mix between Victoria Police, as you are discussing, but also IBAC, who look at more serious corruption issues. So there is a level of that external oversight in the current model.
But the way in which the model works is that the complaints are referred back to VicPol to be dealt with internally.
Yes, a number are referred back, that's correct.
Well, what percentage?
It's very high. I can't remember exactly, but it is a very high percentage.
It would be in the mid to high 90s%.
I believe that's right.
There's
yes.
only a few matters that are kept by IBAC and the rest are referred back to
Yes, that's my understanding.
I think it's 3%.
Sorry?
I think we've heard evidence before that 3%.
3%. We might hear some more evidence about that this afternoon, Commissioner. So, we have already heard some evidence about it, but the report that came down from IBAC in May last year recorded that conflict of interest forms were attached to 84% of files. That means that there was some relationship between the investigator and the person, the subject of the complaint. How can that be understood to be a transparent and open process that people, the public in Victoria can have confidence in? You'd agree with me, it'd be very hard to have confidence in a system where in 84% of the cases, the police officer investigating the matter has a relationship of that they need to declare a conflict of interest with the person, the subject of complaint.
Yes, and I think in the design of presenting the conflict of interest, that is one step of transparency, but given that it is 84% of conflict in investigating, it is difficult.
Can I just ask a question, given you've mentioned conflict of interest, and you've talked about involving the First Nations people in consultations to do programs and to work with our people. Is there any thought given to engaging Aboriginal people, First Peoples, in such an investigation of the police?
Perhaps I can partly answer that, Chair. The department has led a systemic review of police oversight. There are no decisions on the model from that process because they're decisions that government has yet to make. But there was a lot of consultation with community, and we heard very strongly, as Mr McAvoy has noted, that Aboriginal people do not have trust in Victoria Police's complaints system. And we are aware of the extensive number of reports and inquiries that have also shown that. The position from the department is that any model that is landed on, it is critical that there are dedicated people who deal with complaints that Aboriginal people have against police. And the consultation has borne that out. We have heard that it is a critical thing for community to be able to build the trust that they don't feel is there in the system at the moment, and that the oversight model that is in place is robust. It is complainant-centred, it is culturally and practically safe, and that we start to see changes in these numbers and, as Mr McAvoy said, changes in the number of complaints that Aboriginal people feel safe to make about their interactions with police.
I just want to make the point that our people are used all the time for consultations, yes. All the time. We have professional people, we have academics, we have people that are lawyers, we have a whole range of people in different professions, and they should be used as well in this space. And I just want you to think about that, because it's as though we can, help under the table but not over the table.
What is the timeframes for the report that you were just referring to?
So the systemic review, that came out of the Royal Commission into the Management of Police Informants, so it was a recommendation from there, but also part of the policy response to the 2018 IBAC committee report that Mr McAvoy referred to previously. At the moment it's a government consideration, so I don't have timing on that, but it is with government for consideration.
And just off Chair's point there about the consulting, you also did that with raise the age and bail reform, yet none of that's taken on board in the early days. What makes this different, that you're going to actually take this on board?
So I think there's if I may, I might answer that in two parts. One is when the department consults, our key role is to make sure government understands what we're consulting on and what we're hearing. So we do that, and we reflect it, fairly and with the strength that it's given. So if it's a critical issue to community, we reflect it as such. I think what is happening now, in my experience, is consultation is occurring much earlier, and it's occurring certainly in this department, wherever we can at the policy development stage, and that wasn't necessarily the case, and that hasn't been my experience in other places where the policy might be set, it goes to government, and then there's a level of consultation on implementation, and I think that is different. And again, as the Secretary said, it is not self-determination, but it is us learning and growing and walking together to understand earlier what the issues are that we are otherwise not seeing, so that we can address them in the development of the policy before positions are set and approved.
Do you understand addressing them earlier saves lives of people dying in custody? Thank you.
So, Commissioner Lovett asked the question about timing, and I remind you, Ms Chapman, that recommendation number 1 of the IBAC report, Victoria Police Handling of Complaints Made by Aboriginal People, audit report from May 2022, so a year old, calls for recommends that the Victoria Police urgently implements systemic reform of its approach to complaint handling to simplify the system of classifications, determinations and recommendations to help ensure that complainants, investigators and subject officers, and to ensure that the complaints made by Aboriginal people receive a classification that reflects the seriousness of the alleged conduct. Are you aware of whether that's occurred?
I'm not aware, because that recommendation is directed to Victoria Police, but I'm very happy to make inquiries about that. I just don't know the timing that Victoria Police has committed to, or the status of that.
Surely your department has a role in advising on these recommendations as well.
I don't have the document in front of me or the government response, but I'm happy to go back and provide further information where I can.
Perhaps I might ask this question. If an independent external oversight body was established, it would be within the justice portfolio is the likely place for it to be situated, along with the Ombudsman and IBAC.
Yes, that would be correct.
And can you tell the Commissioners whether there are any discussions about that possibility between your department and Victoria Police?
So we have heard in the consultation and from Aboriginal Justice Caucus the strong view of community about an independent model, and often reference being made to the Northern Ireland Ombudsman, which is sometimes referred to as the pony model. So that is an external oversight model, but as I said, at the moment, government has not made a decision on what that model might look like. So I can't offer a view as to that, but obviously that is a model that is in existence and would be part of consideration when government makes a decision.
It is being strongly advocated for by the representative Aboriginal advocacy bodies?
Yes.
Can I ask a question in relation to the lack of confidence by the Victorian Aboriginal community in the existing system? Would you accept that lack of confidence is very deep?
Yes.
And it partly reflects historical considerations that can't be changed?
Yes.
And would you accept that the lack of confidence is in relation to a system involving internal oversight, police investigating themselves?
Yes, that's what we've heard from community.
And
yes.
that's in the vast preponderance of cases, that in fact is what happens now. Police investigate complaints themselves.
The statistics, yeah, would tell us that, yes.
Are you able to comment on how any system involving police investigating themselves would have the confidence of the Victorian Aboriginal community?
I think that is a very difficult and challenging issue, as we've been talking about, both for conflict reasons, for governance reasons. Within the department itself, if we have misconduct allegations, they're initially internally investigated in a separate part of the department, but that's a different proposition when you're dealing with police who have the powers that they have.
Serious powers, yes.
They do. And I think that is the challenge that has to be worked through. And as I said before, we are very cognizant of the deep lack of trust that community have in the police complaints system, and how do we go about building that trust again in whatever the model is.
Whatever the model is.
Yes.
Yes, thank
Can I
you.
just say, you said how we go about building that trust, yet you've consulted. So the information's there.
We've
It has to be
consulted.
taken. It just has to be taken on board, because all we keep hearing is consultation, consultation. And as Chair said, you know, nothing gets taken on board.
Yeah, so we definitely reflected the views that we heard right through that process, and I'm happy to talk in a bit more detail about the consultation itself and, you know, who we talked to and that, if that would be helpful.
I think as First Peoples, we've been over-consulted as well in every aspect.
And we
It's the
did.
fact that you just don't listen. And so how do we get to a point where we've actually listened to and implemented? Our kids are being taken, our people are dying, there's no trust at all, because you just keep asking, but you never, ever put it into what we want. It's half. You know, you've got people that sit on the Aboriginal Justice Caucus, years of experience. Why do you not listen to them?
I think this is part of the challenge of a department giving advice and reflecting those views and trying to give government the options for dealing with those issues. But after that advice is given, the decision is not a decision of the department.
Whose decision
But
is
those
it?
are decisions of government when they involve legislative change.
So is that, would they go to the minister? Would the minister be making some of those decisions?
Well, it depends on what the question is, but it's the department providing advice. So in this case, with the systemic review, we've provided advice to the attorney, and then the attorney, depending on her views of that, if there's a policy shift, it would come back to the department to come up with an implementation plan. If there's a need for legislative reform, it would go through that process. And then,
It's a question for the attorney.
yes,
Can you tell us what advice you've given to the attorney?
we've provided.
I think there's a connection with the cabinet process there, Commissioner, with respect.
Thank you.
I guess where we're going here is we're really concerned about the weight of advocacy around the advice being taken on from our governance structures. You know, we've talked about child protection earlier on in the week, but we're talking to Justice today around caucus having authority or not authority in situations where, again, they've 20, 30, or their life experiences are not taken into account, and when, I guess, the balance of advocacy weighted up, other stakeholders always end up, you know, with stronger outcomes than our people, because the data, you know, is evident of that around the overrepresentation and the indictment on the system that is. Severe indictment on the system of how our people are overrepresented. 15 times, I think it was, for men, and upwards of 22 for women.
I'd just like to finish off on the police situation, in that the relationship between police and Aboriginal people goes back to the protection days. It's been built into the relationship as an official thing to remove people or put them somewhere else, take them back somewhere, or where the people are thought to belong. And there is deep-seated distrust in families because of this sort of behaviour, and yet continue to expect Aboriginal people to assist with consultations about things around No, I think it's very unfair, and it's traumatising for people to have to deal with this in their lives and to have the history, the weight of history within their memories.
I think, can I just sort of say as well, we were talking a little bit earlier about, was it ACJP and that being voluntary, was that right?
Yes.
Yeah. So is there any funding that goes to that program? Because I know that it was one of the ones that was mentioned this morning around success factors. How much funding sort of goes to that?
Not at this stage, no.
Yeah. And that's interesting in itself that, yes, it's highlighted as a great program, but again, it's our people volunteering their time. Volunteering, and I'm not underestimating the weight and volunteering for our people, but again, they're not funded positions, and that's something that we're highlighting here. So I just want to put that on there, that it's, incredibly important that we are highlighting things, but again, volunteering. Our people are worth more than just volunteering their time and efforts.
Thank you, Commissioner. I ask Ms. Houghton or Ms. Chapman, are you aware of the Aboriginal employment numbers in the Victorian Police Service?
No, I'm not.
No, I'm not.
I won't pursue that. I also bring to your attention recommendation number 2 from the IBAC report on Victorian Police handling of complaints by Aboriginal people. It recommends that the Victoria Police develops and implements specific training for Victoria Police employees on the Charter of Human Rights and Responsibilities and its application to Aboriginal people who come into contact with the police to ensure genuine understanding of and engagement with human rights in operational policing, complaints investigations and serious incident oversights. This training should be developed in partnership with the relevant Aboriginal community-controlled organisations and include the historical context and legacy of Aboriginal people's experience with police, the findings and recommendations of the Royal Commission into Aboriginal deaths in custody and the recommendation of the coroner in the inquest into the death of Tanya Day and the impact of cultural stereotypes and unconscious bias on police decision-making. Are you aware as to whether that recommendation has been accepted and acted upon by Victorian Police Service?
I'm not aware, but more than happy to provide that information to the Commission.
Ms. Chapman?
I'm not aware either, as it was directed to Victoria Police, but the department would have the government response to that, so we can find out if it was accepted.
If you could, and provide that to the Commission after your evidence is concluded, that would be we'd be grateful for that. Clearly, the IBAC, in making that recommendation, was of the opinion that the Victorian Police were deficient in their understanding of the human rights of Aboriginal people, as well as the complaints processes and the Royal Commission recommendations and the recommendations of the coroner. The picture that particular recommendation paints is of a police service that really has limited understanding of the fundamental rights of Aboriginal people and Aboriginal people's history in Victoria. Would you agree with that proposition?
I do object. This is not a public interest immunity issue, but we do have Victorian public servants in the box who are observant with the Code of Conduct for the Victorian Public Service, which does put limits on their ability to express personal opinions. Could my learned friend please clarify what frame of reference he's asking these witnesses to comment on an issue like that? If it's just their personal opinion, that's not of great assistance to the inquiry, in my respectful submission, and it could raise issues under the VPS Code of Conduct. Thank you.
Commissioners, with respect, I press the question in that it's not asked on the basis that it's not asked on a personal basis, but it's asked as experts in policy with long-standing and in the government and understanding of government recommendations, and the recommendation from IBAC is fairly clear on its face. And I've asked these witnesses if the conclusions that can be drawn from that recommendation is something that appears on its face to be, in my submission, a proper conclusion. So,
That's correct, Mr Gray.
Yes, if the learned friend will, he's clarified that he's
What's the
asking them to
standard
draw
is
on their
that-
experience
yes.
as experienced public servants and people involved in policy making. I'm satisfied with that. And
Yes, thank you. Thank you.
Ms Houghton and Ms Chapman, you heard that exchange. You understand that I'm asking you as seasoned government employees of great experience whether the recommendation carries with it the suggestion that the police service is deficient in those matters. So the matters, and I'll be specific, that the employees need training in respect of the Charter of Human Rights and Responsibilities and its application to Aboriginal people who come in contact with the police, to ensure genuine understanding of and engagement with human rights in operational policing, complaint investigations and serious incident oversights, and that training should be developed in partnership with Aboriginal community-controlled organisations and include the historical context and legacy of Aboriginal people's experience with police, the findings and recommendations of the Royal Commission to Aboriginal Deaths in Custody, and the recommendation of the coroner in the inquest into the death of Tanya Day and the impact of cultural stereotypes and unconscious bias on police decision-making. Can you accept, or do you accept, that in making that recommendation, it follows that the IBAC was of the opinion that the police service was deficient in that regard?
Well, I've got another objection, I'm sorry, but what can these witnesses really add to a reading of the IBAC report on this issue? The question is currently framed is an attempt to elicit an opinion from these witnesses as to what can be drawn from a recommendation without giving them the opportunity to read the surrounding text. And indeed, the Commission can read that surrounding text and form its own views. So it's simply not going to be helpful to have the Commissioners, to have these witnesses answer a question guessing at what the opinion of IBAC must have been in making that recommendation.
Mr McAvoy, the witnesses have already referred to this matter being before government and the ultimate decision being a matter for it. But you have asked questions about the want of confidence by Aboriginal Victorians in Aboriginal people in Victoria about the police complaint system. I wonder whether you might wish to ask about whether this report feeds into that lack of trust or not, and ask them to comment upon it from that direction.
Thank you, Commissioner. I was going to not press the question as lastly put. I accept that there was a change in the emphasis of the question when it was put a second time. And I will take your invitation, Commissioner, to invite the witnesses to comment on whether the matters reported upon in recommendation 2 are consistent with the Aboriginal community having no confidence in the police service to undertake an internal review of complaints.
From my experience, the need for that type of recommendation would be consistent with the Aboriginal view of lack of confidence.
Thank you.
Mr McAvoy, reference was made earlier to a systemic review which you are undertaking within the department, not at IBAC, that's different. Do you know whether there has been production of documents with respect to that review through the notice to produce process that we have undertaken?
No, Commissioner. It was undertaken through public consultation and targeted stakeholder consultation. So there were some issues papers that were developed for targeted consultation. There was a consultation paper made public on Engage Victoria, and there was also a survey that was open to people to respond to anonymously. So it was more of a positioning and asking rather than a notice to produce approach.
And I'm not being critical here, I'm just asking. It would appear, therefore, that this has not been something that's been the subject of our inquiry or our discussions with the department in relation to production of documents.
Oh, I apologise. I misunderstood the question.
Yes.
I understand that there are some documents.
There has been disclosure.
There has been disclosure.
Yes, all right. We can look into that. Thank you.
I now just wish to ask you some general questions. You agree that good monitoring and reporting is essential to good performance in government?
I agree.
And it is important for this Commission and the public to know that that the focus of this Commission on criminal justice matters, given the government imprimatur to move on policy areas which... sorry, I'll rephrase that. It's important for this Commission and the public to know what the monitoring and reporting will be on the various matters which have been the subject of government announcements will be into the future.
Yes.
It's the case, isn't it, that many of the announcements that have been made in the last 6 months are matters which have been long-standing policy reform issues?
Yes.
Would you agree that the existence of this commission has prompted some action by government to focus its attention on these matters and cause policy reform to occur rather than be discussed?
I think the timeframes were sort of leading into this timeframe in terms of the first year of a new term of government. Yoorrook's timeframes, I'm not sure government has created the coalescence of announcements to when Yoorrook hearings are. But in terms of a new government, the first year of a new government, these reforms, which have been much needed, it would be appropriate to fit within that first year.
The experience of this commission has been that in the days and weeks before certain evidence is to be heard, announcements have been made by the government. And I ask you to accept that's the case. Given that, would you accept that course of action has the strong potential to be seen as a cynical exercise by government?
I'm not going to comment as to the motivations of government. I think the various announcements in terms of the need for bail reform had been made well past this hearing. In particular, the Council of Attorney Generals have been talking about changing the minimum age since 2018, noting it is far later than people had wished. So it is difficult for me as a public servant to comment on the motivations of government.
Thank you. However, you would agree, though, that the ability of this commission to recall yourself and Ms Chapman in, say, 6 months and ask you how the reforms that you foreshadowed and the work that you foreshadowed is progressing is a good motivator and a good measure of a good form of monitoring progress?
Yes, I agree.
While council is thinking, I've been provided the consultation paper, entitled Systemic Review of Police Oversight, dated 25 November 2021. Can I just ask, is that the document to which you earlier referred?
Commissioner, I'm instructed that that is a claim to which
I see.
reasonable excuse restricted access.
All right, I won't go forward. Thank you.
There may be some other way to address.
I appreciate that. Yes, I needn't take it forward.
Thank you.
Ms Chapman, you referred to a document earlier. Do you know the title of that document in relation to the review of the police complaint system?
Mr McAvoy, are you referring to the systemic review of police oversight that the department led?
That's the document that you referred to earlier in 2021?
It's a process. The other document I referred to was the 2018 parliamentary inquiry into police oversight.
Thank you.
Mr. Gray, I just want to tell you I won't be reading the document that I've been provided until any legal issue is resolved about it.
Thank you, Commissioner.
Just for your own comfort, I've got it on my machine. I'll send it back, and I won't be reading it until the legal issue is resolved.
I believe you have to, Commissioner. Could
Oh,
we
very well.
address that outside the hearing?
Yes.
It's just a matter of publication.
Oh, sure. Okay. All right, I'll keep it.
Simply to Yoorrook.
Thank you.
That's my understanding of the status of that document. Thank you, Commissioner.
I've just been informed by Learner Junior that the document is publicly available and it's on the website, Commissioner. It's a matter I'll discuss
we won't resolve this now. It'll just take too much time. We can resolve it later. Thank you.
I just wanted to talk to you a little about the nature of making of successfully pursuing big reform. In terms of big policy reform, timing is always critical. You would agree with that?
Yes.
And do you have any view as to whether the timing is right for some thorough reform in the justice sector as regards Aboriginal people?
Yes, I do.
And what's that view?
So I think timing is right in terms of policy identification, in terms of problem, opportunity, costs and benefits and financial implication. So that whole policy dynamic of understanding of issues and way forward, and the ability to consult, to engage, to inform those decisions. I think we have timing in terms of coalescence with the Aboriginal community, with the appetite of government on a number of things in terms of minimum age, in terms of bail reform. So I think the government's already signalled that the timing is right.
And it assists that you have senior Aboriginal people within the department, such as Mr. Joshua Smith.
Yes, he's...
And the Aboriginal Justice Deputy Secretary position when filled?
Yes, that's correct.
And is the role of the First Peoples Assembly of Victoria one of the stars that might be aligning to assist in the big reform that I'm suggesting to you might be needed?
Yes, that's correct. So the First Peoples Assembly, knowing that the negotiation framework for treaty is settled and negotiation of treaty is forthcoming, is an important component to the timing element.
I'm not sure whether you said this, but it's open to observe that the Premier himself is making many announcements and in the media regularly about this type of, the various types of justice reform. You'd agree with that?
Yes, I agree.
How do you have any view as to how deep the reform process might go?
So I pause because I want to get ahead of any cabinet deliberations or potential cabinet agenda. But in terms of the expectation of treaty, in terms of transformational change, accountability and governance, then in shaping the scale, that from a public service perspective, that is a very big scale.
And so, without, of course, getting ahead of ourselves, it shouldn't be missed by anybody that Aboriginal people existed here for many tens of thousands of years without the type of judicial and legal oversight and control that presently exists. I suggest to you that there is probably much greater room for utilisation of Aboriginal traditional mechanisms in the justice system.
I think all options are on the table, absolutely.
Ms Houghton, do you know whether the government has decided or not to await consideration by this commission of the police oversight issue before finalising its response to the consultation process?
I'm not aware that there is a dependency between the two, no.
No.
That's not, yeah.
I don't think you're implying, are you, that there might be an announcement about this matter before our report comes down?
We're not aware of
You're
any
not aware
such
of that?
plan.
No. And that's not within your hands, I suspect?
No, it may be something you wish to raise with the attorney.
Yes, well, we have the attorney here on Friday. Thank you.
Thank you. Thank you, Chair. Those are my questions of these witnesses. I'm not sure if there's anything which Mr Gray needs to raise.
Everybody?
Commissioners, I would like to come back to you on that document. It does look like the instructions I was acting on might have, in effect, been incorrect because the document is
It might be a public document.
And I wouldn't want to prevent you, Commissioner Bell, from being able to ask your
I
question.
think I've actually covered off the issue I was concerned about in another way.
I do apologise.
Not at all. Thank you.
But that opens the door for council. Should council have any questions?
The issue is one that might also be canvassed with the Commissioner for Police as well.
Yes.
When he gives evidence. I can indicate before the witnesses are released, Commissioners, that it's proposed to tender documents for the whole of this hearing block tomorrow, rather than do that today following this evidence as is the normal fashion. That is a result of the ongoing discussions that we're having with the state about documents.
I've got a question about treaty. My concern, so you referred a number of times about how treaty might be important in this space, but given that we are quite possibly a number of years away from treaty, and especially treaty around the justice space, I'm alarmed that some things may be left for years. So that's one thing that alarms me. The other thing that alarms me is that by saying that somehow treaty is going to fix this, that somehow Aboriginal people are going to be responsible for resolving the problems for a system that they had no say in constructing. It again feels like there's going to be a shift of responsibility to somehow Aboriginal people have to solve this, and having no power in the system but being its victims it seems a little bit of an unfair responsibility and perhaps a little bit of a cop-out.
Just in response, so there are 2 key pieces of reform that are already on the books for this year from a legislative perspective, and that's bail reform and changing the minimum age. I don't think the government is delaying or stopping in waiting for treaty. I think the great goal and aspiration for treaty is the big shifts in terms of accountability and making sure the system as a whole enables that. But again, treaty will be what treaty brings as to parties negotiating. Yep.
So just to finish that off, I would be alarmed if accountability that's needed right now gets deferred for a number of years because somehow treaty is the right place for it. I would suggest
Agree.
that accountability is badly overdue.
Agree.
Look, I think this doesn't matter for today because it depends how treaty unfolds, and there are talks of statewide treaty, which is a totally different thing in relation to how things are going to be managed, and also individual treaties, and we don't know what's going to happen first. I don't think anybody's got a crystal ball in that space, and the elections are not yet held, so I'm sure we'll all be involved down the track.
Thank you, Chair. It will be a bit of a wait and see, I think, in some respects.
Yes.
Ms Houghton, though, I think has agreed with Commissioner Walter that there needs to be urgent action in respect of a number of areas, and that it's not appropriate to wait for everything to be done in a treaty context. I think that's the point that Commissioner Walter was making.
Yes.
Thank you. Thank you.
We heard the statement earlier on today from yourself about, the ongoing systemic injustice. Is there anything further that you'd like to say to our people, our families who have been, again, disproportionately impacted by the criminal justice system continually? Just want to give you one further opportunity to say anything.
Thank you, Commissioner. So it does reiterate the points I made earlier, but to say and confirm from a departmental perspective, the rate at which Aboriginal people continue to come in contact with the criminal justice system shows that we are failing Aboriginal communities. Once Aboriginal people are within the justice system, too frequently we have compounded that harm. We know that the contact with the justice system increases the chances of future contact with the justice system, further entrenching social and economic disadvantage. My department, our department, is full of dedicated staff, including Aboriginal staff, who work hard to address the impact and shortcomings of this system. And despite their efforts and their commitment to justice, the threads of colonial racism persist today and justice is not there and available. I accept that the criminal justice system needs not only to improve, but it needs to address the injustices felt by many Aboriginal people through treaty, but also more urgently. Thank you.
I just want to reiterate, as I did yesterday or the day before, every statistic we've spoken about is a man, a woman or a child. And just on, we talk about cultural awareness, it goes deeper than cultural awareness. The distinct, and I'm sure Commissioner Bell will talk more about this, the distinct human rights of Aboriginal people protected under international law as well as domestic. And there's a component about looking at the Royal Commission into Aboriginal Deaths in Custody recommendations, as well as now Coroner McGregor's findings. These should be embedded in everything you do within the state. And I just want to remind you, and this is from your statement, since January 2025, Aboriginal people have passed in Victoria prisons, 5 too many. And let me honour them right now. Miss Veronica Nelson, Mr Michael Suckling, Miss Heather Calgarrett, Mr Joshua Kerr and Mr Clinton Austin. These could have been, people could have been saved. I have to sit here, we have to sit here and ask why this has happened. These things should never, ever happen under anybody's watch, ever. And remember, when we're doing this, these are our people. These are men, women and children that we, as Aboriginal people, have to face. They come in here with their stories. These families sat in front of us. Some of these families sat in front of us. It's not too late for justice for these people. So take on board what we are telling you. This needs to stop.
We've heard evidence that leave us with no confidence about knowledge of human rights, their applicability in this Indigenous context. Other than that, I wholly endorse what Commissioner Hunter has just said.
Struggling to get human rights, how are we going to get our self-determination or cultural rights? That's something that we're grappling with as a commission. Cultural rights completely different to human rights, in a sense. Yes, there's synergies between the two, but if our basic human rights are being breached, how are we actually going to have confidence, again, that, you know, we can be truly self-determining, treaty or not?
No, thank you. I think finished there. Thank you, Counsel.
Thank you, Commissioner.
Thank you. Adjourn until tomorrow morning.
Sorry,
This afternoon.
no,
Sorry.
Commissioner, Dr Hopkins is the next witness
Oh, today?
today.
Oh, okay.
I have to extend our gratitude to her. She was due to start at 2 p.m.
Yes.
She's ready to go now, but if we might have a 5-minute break
Yes, please.
in order to get ready.
Please. So we'll adjourn 5 minutes, you're saying?
5 minutes, thank you, Commissioners.
All right. We'll resume in 5 minutes.
Thank you.
I hope. Thank you, Counsel.
Thank you, Chair. Just one administrative matter before I commence and invite Dr Hopkins to give evidence. Can I tender the Department of Justice and Community Safety Agency response dated the 15th of March 2023? That's document ID DJCS.0001.0001.0030, and that's a redacted version of that document. So
Okay.
I tender that.
So those documents will be added to the next exhibit numbers.
Thank you. I now invite Dr. Tamar Hopkins to give evidence. Dr. Hopkins, I'd first invite you to introduce yourself to Commissioners, and I understand that you'd also like to acknowledge country. Thank you.
Thank you very much. Yes, I'd like to introduce myself. I'm Tamar Hopkins, now Dr. Tamar Hopkins, and I'd like to acknowledge that I'm here on Wurundjeri country, and to acknowledge all the Indigenous people in this room, the elders here, and elders past and present. And in keeping with that acknowledgement, I'd also like to acknowledge that I am the great-great-granddaughter of a superintendent of Victoria Police who was working at the Criminal Investigation Branch, and that while records of police racism do not exist for that period, I have no doubt that he would have participated in activities that I would feel ashamed of today. And so I'd like to officially apologise for any harm that he may have caused in that position. So, yes, thank you. Thank you.
Thank you. Thank you very much.
Dr. Hopkins, you undertake to give truthful evidence to the Commission today?
I do.
Thank you. Could you just please briefly explain your professional background to the Commissioners?
I graduated in 2000 and started working in legal aid in Canberra, and then moved into community legal centres from 2001 onwards. Then in 2004 moved to Victoria and started working in the Tenants Union and the Social Security Rights Unit. Then in 2005 moved to the Flemington and Kensington Community Legal Centre, thinking that I would be working on tenancy and social security matters, but the doors were open and the young people were flooding through the doors with complaints about police violence and racism, and these were largely young African people and Afghani young people, and so I had to completely shift my practice and my focus and start working on hearing these incredible stories and trying to work out what on earth could be done about the racism that these young people were experiencing. The stories were, I'd like to go into some of the detail of the stories and the Victoria Police response, because I think it sets up some really useful understanding for why the system we have now fails so terribly. So the complaints were, had frequent violence, humiliation, treatment that was designed to humiliate and undermine young people. There was one case where a young person ran from the police and was tackled to the ground, and then the police officer stood with his foot on the head of the young person, smoking a cigarette, waiting for the divvy van to arrive. There was another one where there was a raid on a person's house and a gun was held at a child's head during that raid. In another example, the police threw a Quran on the floor while they were doing a raid of a house. There were people being stopped up to 5 times a day by police officers. They were being hit with batons and police torches and being constantly subject to derogatory statements throughout the process. So what I and my other people at the Flemington and Kensington Legal Centre did was start to collect statements from these young people, and they were absolutely terrified of what was going on, the policing in the area. We were thinking about, can we get restraining orders against these officers? How can we keep these young people safe when they were taken into police stations where some of the violence was happening? I would go in and do bail applications in the police station, which is very unusual, to try and prevent these young people from having to stay overnight in the police station. So a lot of fear. So we started to file complaints with the then Office of Police Integrity, and pointing out that the fact that there was a racialised basis to a lot of this violence. All of these young people were young African and Afghani youths, and asking the OPI to independently investigate these complaints. However, instead of doing that, they sent them down to Professional Standards Command of Victoria Police to investigate. They did initiate an ethical health check of the Flemington Police Station. However, we were never privy to what actually came out of that process. We certainly were privy to the ethical standards investigation of those complaints, however. So there was a process of these complaints being investigated, and at the same time the police initiating charges against the same young people. So we had this horrible situation of a conflict of interest. And these investigators were, they would sit down with these complainants, and basically it was an interrogation. It wasn't, they came to the complainants with the view that they were crooks wanting to make up stories to kind of get out of police charges. The whole process was they'd already come to decisions about these young people before speaking to them. And it was, I heard things like the young people would say they were dragged along the ground, and the police would say, oh no, that's an escort. We call that an escort, we'll write that down. And a racial slur was turned into a communication about issues to do with race. So just this constant sort of reducing the evidence that these young people were given to something that was acceptable to these police officers. I was horrified at this process and stopped the complaint investigation and went back to the OPI and said, I want some undertakings that the investigation into these complaints will not be used to assist the prosecution of these complainants at some point. And eventually, after being told I was potentially hindering police investigations and may be subject to charges myself, there were undertakings agreed to by ethical standards and the OPI. However, that did very little to protect these young people. And there was one story where we had a young person had been hit in the face with a torch, causing his teeth to break, and we were in court, and the ethical standards, he'd been charged with hinder police. So all of these matters, we'd been putting in complaints, and then the charges had come back. And so the complaints were coming back unsubstantiated, but we then had to defend our clients on these charges. With this particular one, the police officer was on the stand giving evidence, and the two ethical standards investigators were sitting at the back of the court watching the process, and the officer was saying, no, I didn't see any blood, or words to that effect, and it was obvious that couldn't be possible. This person had his teeth knocked out and there was blood streaming down his face. There was a break in the evidence, and a co-solicitor saw outside one of the ethical standards investigators speaking to that police witness, and later on he came back and varied his evidence about how much blood was visible. So what we could see was that these ethical standards investigators were in fact participating in the prosecution of these young people, that they were meant to be investigating the police conduct, and yet in fact they were assisting the police to prosecute these young people. And I think that this shows the absolute inherent conflict of interest, that not only I went as far as getting undertakings that this kind of thing wouldn't happen. There was scrutiny from a court. We had senior counsel in the room. I was there, and yet this incredible breach of ethics was going on in front of us. So it made me realise that it's not about oversight of the process. There's actually something inherently impossible about having the police investigating themselves. They are not going to be able to do this independently. So I think it really goes to the heart of what the community is really saying about the need for independent, culturally, hierarchically separate, independent investigation of police complaints. And that is just one example of numerous. I ended up being involved in 12 cases where the complaint had been lodged and came back unsubstantiated, and where a court had dismissed the charges against the person I was acting for, which meant that the arrest was unlawful. So there'd been some amount of degree of illegality in terms of what the police were doing, and yet the complaint itself was unsubstantiated. And these findings really show you that when a complaint can be properly and independently investigated, these young people are believed by independent investigators when they're put to the test. Whereas the process at the moment, which is done on the papers, and where the police just bring in their perceptions of young people being crooks, and I'm talking about young people. It could be a large number of people, but in particular, that's what I was dealing with at the time. So I think that experience, if I can continue, really made me aware of what a deficit system we had of police investigating police, and that something really needed to happen to change this system. So I was able to get a grant to go and study police investigation systems around the world to see, is there a system that is going to work better than this? And I was able to, at the time there was some extraordinary decisions coming out of the European Court of Human Rights, which was really looking at what are the fundamental requirements of a police investigation that would protect the human rights of the individual who was coming before making the police complaint. And if you digest those decisions, 5 principles come out of those decisions. And the first one is independence. So the investigation system must be independent. And it must be hierarchically and culturally independent of the police. So this means not having former police. If there are former police, then really those people must be in very low down positions within the organisation so that it cannot corrupt the culture of what is going on. And what I've seen in Victoria is that our oversight bodies have not been able to keep free from the culture of the body that they are oversighting. So there's been that they have been not culturally independent from the body that they're looking at. And so this is a really critical requirement, that we have a body that actually is there to independently investigate the police and doesn't bring a policing perspective to its investigation process. The second requirement is that that it be effective. So this means that the body actually investigate the human rights breaches that have been alleged, the criminal allegations, the administrative issues, the disciplinary issues that are coming up. So he's able to really get to all of those issues and not just kind of park various parts. And so many times we have investigations where these really critical things have just not been addressed at all in the investigation. So that's really critical. They must be prompt. So it's so important that the investigation can get out there and get that CCTV footage while it's there, contact potential witnesses to an event, and do all of that, do that door knocking straight away. So that's really important. And a lot of the police complaints that I've witnessed have not occurred for months and months, and CCTV footage has been wiped in the meantime, or things like that. Another really critical requirement is that it involve the complainant must be central, the centre of the police complaint. So that's such an obvious thing, but it's something extremely sadly missing from our current system. In our current system, complainants are barely have very little standing other than having put in the complaint. They don't have the right to the material that's coming out of the complaint investigation. They do not have a right to a voice to say what should be involved in the complaint investigation. They're not supported. They're not. So there's a whole lot of failures in terms of that. So and the other thing is that these complaints must be open to public scrutiny. So it can't be done in secret. The public must know what's going on. There must be data on complaints. We must be aware of what's going on. So this is doing this international research was really interesting to be able to look around where was these principles actually being picked up. Was there anybody that was actually able to act on police complaints in compliance with these human rights principles? And the best model that I'm sure you've heard about is the Police Ombudsman of Northern Ireland. And I was able to spend a couple of days there talking to investigators about what they do and how they do it. And they were very consciously complying with the European Court of Human Rights requirements on what an effective investigation should look like. In Australia, we don't have any body that is really acting, putting these principles of investigation in place. So every single jurisdiction in Australia is deficient in terms of meeting these standards. There are certainly recommendations in Queensland at the moment for reforming the system there, which we need to watch and see if they will actually implement what has been recommended out of a recent review. However, the history of complaint reform in Queensland has been a very checkered process, as has the one here in Victoria. So I can go into some of the history of that if needed.
Well, if I can ask you this question, Dr. Hopkins, on the back of that response, does IBAC meet the standards that you've just reflected upon in terms of international human rights law?
Absolutely not.
Why not?
So first of all, it's not investigating matters. So I think in its last two annual reports, I think 2 years ago it investigated 6 complaints of the thousands that were filed with it, and last year it was 5 complaints. So it's in fact a tiny fraction of the complaints that it's receiving, it is in fact investigating. The rest are being referred back to Victoria Police for investigation. And as my earlier example describes, that is just fundamentally not acceptable, that you have Victoria Police investigating itself. The other critical issue here is that IBAC sees itself as one of its jobs is to maintain confidence in Victoria Police. Now that is not independent investigation of complaints and putting complaints central. And this has been a key feature I've noticed in the evolution of complaint bodies in Victoria, from the OPI now to IBAC, is this kind of view that their job is to instill confidence of the community in these complaint bodies and Victoria Police without actually doing any of the work that's required to do that. So, it's missing the fundamental point that people are not going to have confidence until the body starts holding the police to account. So yes, that's a key deficiency. The victim is certainly not central to an IBAC investigation. Just about all complainants that I've ever dealt with and hear from clear that they felt intimidated, alienated by dealing with IBAC and silenced. In fact, IBAC is not subject to the Freedom of Information Act, so complainants can't get access to the investigation that has taken place about them if it's done by IBAC, but obviously the vast majority are done by Victoria Police. So, no, it simply doesn't meet those human rights standards.
If I can, before I ask, I think I'll return to the question of police oversight at the end of my questions, but if I can go back to the genesis of your focus on this work and really the fact that the issue of racial profiling has become the focus of your work. Just as a preliminary matter, we should be clear on terminology. How do you define racial profiling in the context of policing?
Yeah. So there are two definitions that I like working with. The first one is that racial profiling is the unjustified and disproportionate use or abuse of police powers against First Nations or racialised people. So there's a couple of important things in that. We're talking about unjustified and disproportionate use of police power or failure to use police power against First Nations and other racialised people. So what's really central about this point is that it's looking at not just disproportionality, which is what most of the statistics that are produced about how the criminal justice system works are about disproportionality. This is actually about unjustified and disproportionate. So it puts the spotlight back onto the unjustified, unreasonable use of police powers against First Nations and racialised people. So it's a really important point, and I think it's been kind of missing in a lot of kind of looking at data that tends to blame those that are affected by the criminal justice system. This really allows us to pinpoint and zero in on the police role in generating those disproportionate outcomes.
In 2009, I believe it was, you were one of the founders of the Police Accountability Project at Flemington Kensington Community Legal Centre. The project has engaged in a number of projects, particularly on racial profiling, but also as part of that work has engaged in some strategic litigation. You were involved in the case of Hale Michael and Constantinidis, which was filed more than 10 years ago and settled in 2013. Could you let the commissioners know what that case was about?
So this was a case that was filed in 2008. And really, it was filed in complete horror at how the complaint system had failed these young people. There was no justice coming through the complaint system. They had been defending themselves in civil proceedings and that had worked successfully, but those police were not being held to account. So we filed in the Human Rights Commission. There were 17 young people who filed there, setting out their complaints of being assaulted, being constantly stopped and searched, being mistreated in public places and in private places. And the theme was that this was a pattern of racial discrimination involved in each and every one of these young people's experiences. So we filed these complaints in the Human Rights Commission. It took 2 years of process, including mediations, which I can't speak about, and then it was eventually filed in 2010 in the federal court. And at that point, we're suddenly entering a cost jurisdiction, and it's our legal system's processes are all problematic for victims trying to get justice. Suddenly, because we're in a cost jurisdiction, there's a risk that if we fail, there may be a huge cost risk facing these young people. And so we ended up putting in a protective costs order. But to apply for a protective costs order, we were advised that the young people needed to be running this for public interest purposes and not private compensation purposes. And so they had to remove their claims for seeking compensation as part of the claim. And that was very upsetting and distressing for a lot of young people who withdrew at that point. We were simultaneously running separate civil claims seeking damages for young people. So there were multiple processes going on at this time. Anyway, so we were then from 2012 to 2010 was when that was filed, to 2013 in the federal court, trying to get this matter on for hearing and also trying to get material out of the police to demonstrate the racialised nature of their operations in Flemington. So something that I didn't go into was that in 2006, when all the complaints were coming in, there in fact had been an operation put in place, Operation Malto, headed by Forward Commander Nick Constantinides at that point. He had a prior record of complaints, racially motivated police behaviours, excessive force. So he had that history of prior complaints, which were unsubstantiated. Nevertheless, the history was there, and yet he was put into this position of Forward Commander leading Operation Malto. And the texts of the operation were that it should focus on young African men in the North Melbourne and Flemington area. So it's clearly directed in a racialised way towards these young people, and it certainly was experienced as almost a war zone. In fact, it was experienced as a war zone. It was extremely distressing for those young people to be stopped constantly in this process. So, when we were able to get material from Victoria Police, information about Operation Malto was one of the things we could get. The other thing was we were able to get some data from the police about their field contacts for a period of 4 years in the Flemington and North Melbourne area. And those field contacts were then analysed by a statistician, Professor Ian Gordon, and also looked at by Professor Chris Cunneen, and that we were asking them as part of the process what their thoughts were on whether this could constitute racial profiling. The reason I can talk about this is that the settlement of the case included the fact that this data could then be described publicly. But what the data showed was that young African and Middle Eastern youths were being issued with field contacts at a rate of 2.53 times the amount that you would expect from their size in the population. So that was a disproportionality ratio. Field contact reports at the time were issued by the police whenever they stopped someone. So it wasn't issued when they arrested a person. It was below the standard for arrest. It was just a stop going on. And so these young people were being subject at this greater rate to these kinds of stops and questions. So, yeah, that was some of the data. Now, when the case settled in 2013, it was a really... I can't talk too much about the process of the decision-making to settle, except that it was a shame not to be able to cross-examine the police involved in that case and settle instead. But we did get the police to agree to release the data and also to institute twin inquiries into their own conduct. They in 2013 agreed to run an inquiry into their field contact practices and an inquiry into their multicultural training. And those were, there were two independent investigations, inquiries that were run, one by Circa, which is an Indigenous research organisation, and one by Victoria University. And they accepted public submissions into those processes. And they, at the end of 2000, they were provided to Victoria Police in the middle of 2013. And then at the end of 2013, Victoria Police released a report called Equality is Not the Same, where it agreed to fundamentally change its practices with regard to dealing with racial profiling, dealing with field contacts, dealing with the public. So what happened then? So this Equality is Not the Same report, I guess we were excited that we'd never seen anything like this happen, so we were curious about what was going to happen. They set up a whole new, they restructured and created a new department, the Priority Community Division within Victoria Police, which was meant to ensure that the police were not engaging in discriminatory conduct in any way. And the report said that they were going to improve their complaint system radically and start monitoring their conduct, or consider how to monitor their conduct and change their policies. So in 2005, they did introduce some new policies, and 2015, they introduced Australia's first ban on racial profiling. So that was a significant policy shift, but unfortunately that ban was not accompanied by any mechanism to monitor that that policy was being enforced in any way. So there was, it remains a completely empty statement in a policy document, and we were very distressed about that, because there's no way that that's going to change anything. Sorry.
Yeah, I think you're about to go where I'm about to go. So I think that led to, in 2017, is that right, through the Police Stop Data Working Group, to issue a report titled Monitoring Racial Profiling, Introducing a Scheme to Prevent Unlawful Stops and Searches by Victoria Police, and you were the lead author of that report. And the key recommendation of that report was to introduce a data collection and monitoring scheme. What's the importance of collecting that type of data on racial profiling to attempt to mitigate or stop some of the problems that you've identified from arising? Yeah.
Well, there's a number of really critical reasons why we need data to monitor what's going on. If a mere policy that is not accompanied by any practical machinery to ensure that the police are not racially profiling is meaningless. So what a data monitoring scheme does is actually start to track what the police are doing on the streets, when they're stopping and questioning and searching and engaging with the public, and start to see who is being impacted by those police decisions, and on what basis. Was there any justification for those interactions? Could they be lawfully justified? What was the basis for what was going on? So it's really critical to get a picture of what exactly Victoria Police is doing on the streets when it deals with the community. So that's one particular function. The second thing is it allows us to actually get some context into where places where is out of control, where is doing well, can start to actually, get a map of how Victoria Police is doing in terms of how it's treating the public. And the other thing is to start forcing the police to record their reasons for why they are interacting with the public, so that it can't just be these random intercepts or no reason stops, but that we're actually seeing what it was that crystallised that decision to interact with that person. So hopefully by having that mechanism, it will actually start to reduce the interactions between the police and the public.
And look, it might be obvious, but can you just step out why that type of data collection might act as a prevention scheme?
Yeah, so by being forced to articulate why you're stopping someone, and having that there being a monitoring process, it forces the police to start to question their practices. So this goes to the heart of their daily, everyday interactions with the public. So by actually forcing them to articulate down on a piece of paper what it was about what this person that I decided to stop, that should actually reduce the large numbers of unjustified stops that happen on a kind of a regular basis by police. So it actually starts to tighten up their contact, and it also allows for the public to know what the police are doing. Like, what are we doing funding a police operation? What's actually going on? Is it interacting in a racially discriminatory mannerism with the public? Is there racial profiling going on?
That report was prepared independently but provided to Victoria Police. Do you know what Victoria Police's reaction to that report was, or whether they accepted or implemented any or all of the recommendations?
Yes. So I have 3 copies of this report here that I'm really happy to leave for commissioners. So we attempted to meet with the police on a number of occasions to talk to them about this. What we were really doing was they had raised a number of concerns about what might happen if data collection happened, and we wanted to look at how data was collected around the world and show how those concerns had been mitigated in other places, so that they could no longer keep voicing these issues that they were raising. And so we addressed their concerns very clearly in this report, and yet they still came up with these issues. So really, it was like our attempts to get somewhere with them were just met with a brick wall in terms of any real introduction. And in fact, there were groups Victoria Police set up some transparency working groups and human rights monitoring groups, and the Flemington Kensington Legal Centre at all times was kept off those groups, not allowed to participate. And so it really seemed like this was too hard. We're not going to deal with it. They just didn't want to engage with our process.
In terms of some of those concerns with the type of data collection, are we talking about in terms of privacy concerns, the collection of racial data itself being racialised? Is that the type of concerns that are being raised?
Yeah, so there's concerns, and of course there are always concerns when you're collecting data about private data about people. And the fact is that data has been misused against First Nations and racialised people for years, so it makes a lot of sense to have concerns about the use of data. However, as I've explained previously this data is not being used to indicate or blame communities, but rather to turn the spotlight back onto Victoria Police's practice and show which communities are they targeting? Where is this unnecessary use of police power being carried out? So it's really about, it's shifting the spotlight and allowing us to look at systemic racism, it's really critical that we collect data about this. It's not critical that we collect data about crime rates. That doesn't go to systemic racism, but collecting data about the way the system unnecessarily criminalises people is critical. So this data is about looking at that unjustified criminalisation of racialised people. So it's that particular issue is we've met that key concern that was raised. The other issue that came up was how do you collect data on race? Now, the issue of racial profiling is about police perception of race. It's not about reality of race. So we are not interested in whether the police have it right. We want to know is if they think they're dealing with a First Nations person.
Your purpose for undertaking that research and what were the key findings of your research?
Yep. So the reason I did this research was to we have so much evidence of brutal policing towards Indigenous and other racialised people. But what is missing in data at this stage is a comparison between how much is this kind of brutal policing, how much do white people experience this? What's actually going on? What's the comparative experience? And it's something that that has been noted that we have data, but where's the comparative information? Because I've gone through this process of trying to get Victoria Police to collect the data that we could use to do this kind of comparative work, and at this point had hit a brick wall. The strategy that I used in my PhD was to use a survey of the public to get hold of this data. So the purpose is really to explore, are people really being treated differently depending on their racial experience? Can we actually get evidence of this? And so that's really the question. Can I show that? Can we get data that shows there really is this kind of differential treatment going on? So that was what was led me to kind of investigate this particular issue. I guess I'm coming at this from as a lawyer who is considering how do we prove racial discrimination cases, what kinds of data might be useful in terms of individuals bringing claims that they have experienced racial profiling, and knowing that data could assist those kinds of claims in court. So they were some of the reasons for doing this.
And I think one of the key findings of your report was that there was strong evidence that race is associated with decision-making by police in Victoria about who to subject to high discretion stops and unjustified post-stop conduct. Can you just expand for the commissioners a little on that high-level finding in your PhD?
Yeah. So the survey produced extremely strong findings that showed very, very statistically strong findings that there is a dual system of policing in Victoria at the moment. So the experience that white people have when they are policed is very different from the experience of racialised people. And that difference is even more acute to a particular subset of racialised people. I looked particularly at a group which I called targeted racialised people, which were looking at Aboriginal people, African people, Pacific Islanders and Middle Eastern, to see is there, so overall, was there a difference for racialised people? And then if you were in one of these categories, what was the experience? And I found very strong evidence, and when I'm talking about strong evidence, I'm saying that the p-values from the statistical tests, the regression analysis that we were doing, were less than 0.001. So it's very, very small p-values for most of our findings. So, for example, when we looked at the reason that police stopped an individual, so comparing racialised people with white people, so if it was a high discretion stop compared to a low discretion stop, I found that there was that racialised people had 2.8 times the odds of being stopped for no reason than white people, and that targeted racialised people had 3.6 times the odds of being stopped for no reason than white people.
Just to be clear, so there's a hierarchy of, as in all the negative connotations of the hierarchy of your likelihood. It's not just being racialised, it's actually specific groups are more likely than other
That's right.
racialised groups to experience this.
That's right. So if you're Indigenous, if you're African, if you're Pacific Islander or Middle Eastern, you have an increased rate of being stopped for no reason.
At more than three the odds ratio.
That's right. The odds ratio is 3.6. That's right. So that was very strongly significant, that data. The other finding, and these are vehicle stops, was looking at when the police actually stop someone, what was the post-stop conduct, was it reasonable or not? So did they, so for example, reasonable post-stop conduct would be if they've caught someone for being on a mobile phone, requesting to see that mobile phone might be a reasonable post-stop conduct. Stopping someone for a random intercept followed by a search of the vehicle was not reasonable post-stop conduct. So I was looking at the descriptions provided by people to make a judgment about whether or not the conduct flowed from the stop reason and justification, or whether it was it didn't flow. And I found that racialised people had 5 times the odds of being subject to unjustified post-stop conduct than white people, and that targeted racialised people had 7.4 times the odds of being subject to unjustified post-stop conduct. So these are really very concerning differences in the way police are treating people, depending on their perceived racial appearance.
And your PhD also set out your finding that there were 17 tactics that were disproportionately applied to Aboriginal, African, Pacifica and Middle Eastern or Muslim appearing people. And just for the benefit of the commissioners, I won't run through all of them, but just for some of them, that for those groups of people, it was 4 times more likely that a stop reason, including stopping a motorist to investigate if their car was stolen, that once the vehicle was stopped, there were 4 times the odds for those people that the passengers were questioned, 13 times the odds for asking passengers to leave the car, twice the odds of asking a driver why they were in the area they were, twice the odds of doing licence and registration checks, and twice the odds for searching vehicles. And for pedestrian stops, there were 3 times the odds that a stop reason, including stopping a person because they looked suspicious, 3 times the odds to ask them if they've seen someone, and 3 times the odds of stopping them because they looked away. And in relation to post-stop tactics, there were 11 times the odds that an inappropriate racialised comment was made. In light of those findings of your research, what conclusion did you draw in particular about the random nature of racial profiling? So
my conclusion was that the Victoria Police were engaging in racial profiling, and that when and that by the definition that the unjustified use of police power was disproportionately being used against these racialised people and First Nations people. So I concluded that that racial profiling is existing in Victoria, and this survey was done in 2018, 2019, some 3 years after the policy that was introduced by Victoria Police to ban racial profiling. So, yeah, my conclusion is that that policy has been absolutely ineffective at dealing with this issue, and that it's an ongoing problem.
And a final question directly on this issue of racial profiling before briefly returning to the issue of police oversight. You've mentioned at the end there the zero tolerance policy against racial profiling. The commissioners are grappling in a variety of areas with the disconnect between policy and practice. And I just wanted to get your reflections, having done the work that you've done on racial profiling, in the face of what you said was a world first policy around a complete ban on racial profiling in 2015, what your observations are about that disconnect. We talk often about closing the gap for First Nations peoples. How do we close that gap, in your opinion?
Yeah. So just to correct you, that's a Australia First policy.
Australia First, sorry.
There are certainly bans on racial profiling in other jurisdictions around the world. Yes, so what that really clearly shows is that it doesn't matter what you have in your police manual. There you need to set up operational changes to the way the police do their business. The issue is that policing, this kind of random stopping of people that the police think are suspicious, is not, there is no legal basis to do that kind of random stopping. The stop powers are very specifically provided under legislation for specific reasons, not for kind of following up on your suspicion. So really what this challenges is the very a major operational practice, which is routine, random stopping and questioning of people on the street, and that these random everyday practices are intensely racialised and creating these very kind of different experiences for people depending on your racial appearance. So what is really needed is a change in the everyday practice of policing, and a pulling back, police really attending to stopping when they have a genuine reason to actually pull over someone, like they've sped or gone through a traffic light, not just because they are suspicious.
Is going back then to the question of police oversight, is an independent and hierarchically and sufficiently independent police investigation system also, in your opinion, a necessary element to ensure that racial profiling does not exist?
Absolutely, it's a critical element. So what needs to happen is that there needs to be independent monitoring of the police application of these policies, and that needs to be done independently. We can't leave that to Victoria Police to monitor, and we need independent investigation of complaints. And that without the effective monitoring and investigation of police activities, these policies remain worthless. They're just in the manual with no mechanisms to ensure they actually take place. So it's a critical requirement to stop racial profiling. There are other ones, if I could suggest, that we need as well. One of the key things, in my experience, having gone through multiple iterations of complaint, the complaint body has reformed from the OPI to IBAC. We've gone through numerous reviews where recommendations have been made and nothing has been done. The government has not introduced an independent system. The police have created policies that have not been acted upon. I think we need to really start revisiting the role of police and what they do on the streets, and start really investigating alternative first responder models that don't involve police and that are actually about providing wraparound care for communities in the way that they need it, in a non-criminalising, supportive way. And that we have relied on the police and engaged them in activities that are causing harm rather than support, and that really thinking hard about pulling back police from their role on the street is essential to deal with racial profiling.
In terms of complaints about police conduct, are you aware of the IBAC audit report from July 2022 on Victoria Police's handling of complaints made by Aboriginal people?
Yes.
At a high level, from the press release summarising the findings, IBAC stated that the report identified police use of force as the most frequent complaint by Aboriginal people, and that a significant number of the complaints and serious incidents involved Aboriginal children and young people. It also found very few complaints were determined by Victoria Police to be substantiated, and in addition, a large proportion of the complaint files contained indications of bias or a lack of impartiality. And IBAC raised concerns with the Victoria Police complaint handling systems and processes, including how Aboriginal status was recorded, a failure to keep the complainant updated on the process of the investigation, and conflicts of interest being poorly identified and managed. What was your particular reaction to that report directly in the context of the handling of complaints by Aboriginal people?
Yeah, I was surprised that IBAC had done a report like that. However, and clearly, I mean, those are strong findings against Victoria Police and what they were doing. However, these kinds of recommendations have been made to Victoria Police previously. And so I guess I'm once again wondering, why is IBAC offering suggestions to Victoria Police to improve its practice when that is not going to happen? What is needed is independent investigation, and that IBAC is not making the key recommendation that it should be, that will actually, there is no way the police will in a non-biased way investigate complaints about Indigenous people. It's just not simply, we do not have any evidence that they've ever been able to do this in a non-biased way. So I guess I feel like IBAC has not said what is needed here.
And you had mentioned earlier in your evidence the high rates of return of complaints to IBAC back to Victoria Police for investigation, and am I right in saying that most of those complaints are dealt with by the Professional Standards Command in your experience?
So in my experience, what happens is that they go back to Victoria Police, and a very small minority are investigated by Professional Standards Command, and the majority are then sent out to police in the regions to investigate. And that frequently involves police officers investigating people from the same station who are under their hierarchical command, and they may well have had some involvement. As we've heard about the conflicts of interest, this is a standard practice.
Specifically about Professional Standards Command, it's the division that promotes high ethical standards within the police force. Have you had experience in dealing with complaints that have been dealt with by Professional Standards Command?
Yes. So in the Flemington complaints, they were investigated. They were all investigated by Professional Standards Command, and they were. I think we had some procedural findings that some procedural thing had not been complied with, but all the assault complaints were found unsubstantiated. So the bulk of those were found unsubstantiated. And I've described to you the way that those Professional Standards Command investigators were interrogating the clients that I was working with in a very intimidating way that was set up to really probe for potential criminal offences by those young people and not to get to the bottom of the complaint that they'd made. So it was very clear, they had a clear agenda when they were coming in to do the investigations.
Just finally on issues of on police oversight, and I know you've mentioned the Northern Ireland model, and what would you say in a perfect world, if you had the capacity to recommend a particular system of police oversight, and this is a question the commissioners will have to grapple with as well in the context of First Nations people in Victoria. How would you design that system of police oversight, particularly in order to attempt to eradicate the problem of that you've identified of racial profiling?
Yeah. So I think it's really critical that the organisation be thoroughly independent, but also that it has, if that's what First Nations people are wanting, a First Nations investigation unit that is run by First Nations people and is for First Nations to manage First Nations complaints. And I'd say this is required not just for First Nations, but for a whole lot of highly marginalised people that interact with the police, with Victoria Police, and are currently unsupported and through the system. So we would need to really carefully think about how the QI community is supported, how other racialised communities, people with mental illnesses, people with lived experience, survivors of family violence. So it's the model needs to really take into account the experience of complainants and ensure that the investigations are handled by people who have experience within their reference.
Of course.
Can I just be clear? If you talk about sort of a unit of First Nations people that are First Nations people, that would need to come with some level of authority. Is that what you're saying?
Yes, absolutely.
So for any sort of group that's within there, that unit, so they would need to have a level of authority that is able to hold people to the police to
Absolutely.
It's not just an add-on unit for, say,
a liaison unit or something like. No, not at all. No, absolutely. Yeah.
Thank you.
Yep.
My final question was just to provide you with an opportunity to say anything else about these issues to the commissioners that you might have missed, particularly in the context of this being a truth-telling commission and the important work that it does. So if there's anything else that you wanted to raise, please feel free.
Thanks. There was something I was wanting to mention about when I'm talking about Forward Commander Nick Constantinides, who was running Operation Molto in Flemington, and how some years afterwards we were in our police complaints clinic at the Flemington Legal Centre. We had a phone call from Nick Constantinides, who had been promoted to become a sergeant and was in fact working in Ethical Standards Command and was investigating one of our clients' complaints. And the shock that someone who was the lead respondent in the Hale Michael race discrimination case, Nick Constantinides, was named in the document and had been, we're aware, the subject of so many complaints, was now acting as an investigator at Police Complaints Command. And the other highly concerning aspect to this was that during the Flemington matters, the superintendent of the area was Superintendent Brett Guerin, And he was intimately aware of the issues that were going on in the Flemington region, and was then appointed to a position in Ethical Standards Command. And I remember having a conversation with him after he was appointed and saying, well, look, you know, we're not going to be satisfied until the police who've engaged in misconduct against our clients there is some accountability. And he said, you know, absolutely, you have my word, there's going to be accountability. And a couple of years later, we find out that Nick Constantinides is in there. So there's been no accountability then. And then we discover that Brett Guerin himself has been engaging in racist and sexist comments that he's been putting in the media. So those are reported in the media, so I don't need to kind of go into too much detail about them. But I think it just shows the difficulty, the impossibility really of Victoria Police. I guess I had this sense of frustration that we can't rely on the things that are said to us, that while many of the documents that they produce are really excellent, the reality is that nothing is changing. And so something is really needed in this space. Something very different is needed in this space. So, yeah, really grateful that this commission is considering these issues. Thank you.
Very much.
Thank you, Chair. And if there are any questions from the commissioners.
Oh, look, I've got a comment to make. You've given an extreme example of a policy which was completely devoid of monitoring and evaluation. So what it did was nothing, while giving the appearance that somebody cared. We have heard over a number of different areas now a similar thing where frameworks and policies are put in place, but there has been no, despite promises of monitoring and evaluation, that actually hasn't happened. And it seems that there is a pattern here of you putting a policy and the state putting policies or frameworks in place, then not monitoring them, which really just allows the state to say, look, we're trying to do something, but it never disturbs the status quo. So no change occurs. And it's very perverse.
It really is, yeah. And we have to wonder how serious are these policies if they're not, there's nothing to monitor and implement them being put in. And it seems, I frequently wonder what is blocking change in this area. You know, how come they are so on notice about what is needed and nothing happens? And looking at, you know, potentially the power of the police union to really stifle some really important changes that are needed. And I think we've seen again and again Labor governments failing to enact anything that is needed. And I guess I'm questioning the relationship between Labor governments and the police union. But I have to say that also when the Liberals do get in power, they're not doing anything in this space either. So we don't have action on either side.
I just want to say thank you for being brave enough to do this work. I don't think there's many people that would take this on. And thank you for waiting for so long this afternoon too.
Yeah, thank you. Thank you for that outline. It's very, very interesting, very disappointing. But the bottom line is the level of racism behind this. I mean, there's no escaping it. And I lived in that district for some time and I saw the population changing to what it is now. You know, I never saw it get to this, to the makeup of people that it is now, but I saw it changing at the time we were living there, from mostly people who were white coming from overseas to a mix of brown people. And it's just there. It's just there.
Yeah.
Racism's at the bottom of it, and it's expressed in all these other ways, which is so hard to bear, really. Thank you. Thank you.
Thank you.
Thank you, Chair.
Thanks.
I think that's the end of our programming for today. You'll be grateful to know, and we'll be back tomorrow.
Okay, thank you. We'll adjourn. until the next sitting, which I think is Thursday.
No,
Tomorrow.
today.
Who have we got tomorrow? Yeah, I've got no,
Skip today.
yeah,
Yes.
okay.
Today's Tuesday, believe it or not.
Sorry.
We have we'll continue with some Department of Justice and Community Safety witnesses
Yes.
tomorrow.
Yes, sorry, I've got the wrong information
And Youth
here.
Justice, yes.
Thank you.
Thanks. Thanks, Sarah.